Test. Morning. Oh, we are on, by the way.
Okay, we're all set.
We good? Good morning, I'm Jeff Ashby. And on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device to ensure that they are silent now. We have additional agendas, including the consent agenda, made available, I believe, electronically and also in the back of the room. I picked one up on the way in. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission has voted on those cases and they'll be not considered further today. And
before you adopt the agenda, I have given you all a memo on a request to withdraw in E21-0273 McKenna versus the Brunswick School Department. We need to vote on that now because if you grant that request, it will change the agenda. And our remote.
Did anybody else just lose sound?
Sorry, are we having issues with the sound? Sarah is nodding.
Yes, I think it muted, and so the whatever you just heard, I think we couldn't hear.
Is the microphone on, Chelsea? Yes. Okay.
We can hear you now.
Okay. So Commissioner O'Brien just made a motion to deny the request to withdraw in E21-0273 McKenna versus the Brunswick School Department. And Ed, did you second?
Yes.
Okay, so it's been moved and seconded. Any discussion? Being none, if you vote yes, you are in agreement. Commissioner Ashby,
yes.
Commissioner Davis,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
Great. Thank you. Okay, and so then we, yes,
I voted on that. I can vote on whether that stays on the consent agenda. That's not my
Oh,
conflict.
yes, gotcha.
the one we can't vote on.
He's gonna abstain
I have a
on
conflict
the
regarding the consent
general
agenda.
consent
And I'll
agenda,
just
so
abstain.
I just didn't hear
Okay,
whether we've done the whole thing or not.
I
So-
will, however, entertain a motion to adopt the agenda and the consent agenda.
Move adoption of the agenda and the consent agenda as amended.
Second.
been moved and seconded. Any discussion? Seeing none, if you vote yes, you're in agreement. Commissioner Ashby,
Abstain.
Commissioner Davis,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Douglas,
Yes.
Commissioner Walker.
Yes. Minutes of the September 2023 commission meeting.
Move to adopt the minutes of the meeting.
Second.
Second.
All right, it's been moved and seconded. Any discussion on the minutes? All right, seeing none, if you vote yes, you are in agreement to adopt those. Commissioner Ashby.
Yes.
Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas,
Yes.
Commissioner Walker.
Yes.
Yes. Okay, so you have a memo from me about personnel. Our update is that Melody Piper, who was our Director of Operations for as long as many of us can remember, resigned last month. We are in the process of getting that job to HR to post, and hopefully we'll be doing that sometime in the next few weeks. You have a memo purporting to be from me, but actually from Jane O'Reilly outlining the status of reasonable grounds cases. Since the last meeting, we've had 3 successful conciliations, no unsuccessful conciliations, although I will say 2 of the pending Conciliations have been unsuccessful at the commission, but still have some time left before they officially fail. So you'll probably get those on the next memo. We've had 69 new charges in September, 4 administrative dismissals, 4 right to sue requests, and 13 predetermination settlements for a total of, I think, about $245,000 to complainants. I would ask that we take litigation after executive session, and I have no new business.
Wow.
For this month.
We could take the remaining 9 minutes before our meeting starts to discuss the award of the Dana Award if we.
Tell me more.
Well, just that one of our members has been, that award's been bestowed upon him, and it's a real honor, I think, as a practicing. Congratulations.
Thank you.
We still have 9, still 8 minutes.
Sorry.
We'll be back. We'll take a break. We'll be back here at 8:45. Hello again. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As we call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments in the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions. We ask that you introduce yourself as you approach either the podium here today or are recognized online. The first case today to be heard is E21-0452A and B. That's Kimberly James versus the Maine State Police and Lieutenant Michael Zarbarski. That is a no reasonable grounds case. And so I believe we'll hear from the complainant or their representative.
Just remind everyone participating today to please not use the names of third parties in our reports. We've given them pseudonyms. The MHRA requires the commission to maintain their confidentiality. So we're asking those presenting here to do the same. And Attorney Beard, you had asked to split your time between yourself and Ms. James. Did you want to do that equally?
So we decided not to proceed that way. I'll just present for us.
Great. So you have 10 minutes. Do you want to reserve any of your time?
Yes, if you could please let me know when I'm at 7 minutes, I'd appreciate that. Morning, commissioners. My name is Braden Beard. I'm here representing the complainant in this case, Kim James. So our objection here comes down to 2 primary points. The investigator's report was thorough, but I think sort of missed 2 aspects here that I think changed the outcome. First, the report analyzed the retaliatory acts of Ms. James' supervisor as sort of discrete individual instances of retaliation rather than looking at them as a whole. And when viewed that way, I think it's clear that this amounts to a retaliatory hostile work environment. Second, the report does not address evidence of pretext from Lieutenant Zabarski, one of the respondents here. Untruthful statements made both during the fact-finding conference and statements he made during the fact-finding conference that demonstrate that earlier written statements were not truthful. And these 2 elements combined, I think should lead the commission to reject the investigator's recommended finding and instead find that there are reasonable grounds to believe unlawful retaliation occurred here. So first, on the retaliatory hostile work environment. So as you know, the relevant standard here is, did retaliation occur that could dissuade a reasonable worker from making or supporting a charge of discrimination? And the investigator's report looked at a series of retaliatory acts separately, and decided that each one of these individually did not amount to the level of unlawful retaliation. But the commission should look at these as a pattern of hostility collectively, or as a retaliatory hostile work environment. And to meet that standard, an employee must show that the hostility was severe or pervasive, and that it extended beyond the normal tension that exists in many supervisor-supervisee relationships. And what respondent did here did rise to that level. Just sort of running through the instances, coming into her office in full uniform with his firearm, which is not what he normally wore around the crime lab, yelling, becoming angry towards her, telling her, if you're going to be insulting in written communications, I prefer you tell me to my face. After that, refusing to interact with her directly in the months that followed, not acknowledging her in group meetings, excluding her from a electronic team leaders calendar that included the other section leads within the crime lab, telling staff members that she could not be trusted. And the hostility really continued throughout the MHRC process. Most recently, in Lieutenant Zavarski's close of evidence submission, he fabricated a list of alleged deficiencies in Ms. James' job performance that have nothing to do with the events of this case, just to further try to make her look bad. And second, sort of moving on to the pretext aspect of this, which, as I said, I think kind of combines with viewing this as a retaliatory hostile work environment. So there's no reference to pretext in the investigator's report, even though this is a critical type of evidence in these cases. In these cases, this is quoting the Supreme Court, trier of fact can reasonably infer from the falsity of the explanation that the employer is dissembling to cover up a discriminatory purpose. Pretext may be proven with weaknesses and plausibilities, inconsistencies, incoherencies, or contradictions in the employer's proffered legitimate reasons for its actions that a reasonable fact finder could rationally find them unworthy of credence. And the reasonableness of an inference of retaliation from an employer's pretextual explanation is reinforced by, again, according to the Supreme Court, the general principle of evidence law that the fact finder is entitled to consider a party's dishonesty about a material fact as affirmative evidence of guilt. So, key example here, Lieutenant Zabarski's testimony during the fact-finding conference in this case contradicted what he had put in his written answer to Ms. James's MHRC complaint. There, he wrote, he did not reprimand or criticize complainant at all. At the fact-finding conference, he admitted making the following statement, which I think could very reasonably be viewed as combative and criticizing, that if you're going to be insulting in written communications, I prefer you tell me to my face. Respondent also claimed that he had decided to report the sexual harassment that Ms. James ultimately reported, that he had decided to report that to HR independently. But as the report correctly found, respondents actually did not initiate the call to HR until Ms. James informed them that she would be reporting it to HR. So these inconsistencies, this lack of truthfulness leads to a clear inference here that respondents were concealing the truth because it was illegal retaliation. So when the commission evaluates the totality of the retaliation here as a retaliatory hostile work environment, it considers the strong evidence of pretext. The commission should find that there are reasonable grounds, at least an even chance, to believe that respondents unlawfully retaliated against Ms. James for engaging in protected conduct. Happy to answer any questions.
3.5 minutes. Commissioner questions, yes, Commissioner David.
How does your argument that there's a pattern of hostility go together with the report that found that she exceeds the employee evaluation, that she exceeds expectations?
So the written report was, for one thing, completed over time, including in part before the pattern of retaliation really began. And yes, in writing during the evaluation meeting, the evaluation was positive, but sort of everything around it in the meeting was negative. Respondents did not focus on the positive aspects of Ms. James's performance evaluation, instead focused on complaints about the way that she went about raising her subordinate's sexual harassment complaint in respondent's view, going around him, going outside the chain of command, even though, as the investigator properly found, she was properly following state policy on reporting these things to HR. And then the hostility sort of continued from there.
The other thing that bothered me is that you said in your submission, and you say here in argument, that you take issue with the fact that he's wearing his uniform. He's a Maine state policeman. Why shouldn't he be wearing his uniform?
So he's not a trooper who's out on patrol for the most part. So in Miss James' experience working in the crime lab with him day to day, it's extremely rare that he wears his uniform, that he carries a firearm. And when you look at kind of collectively what happened in this evaluation meeting, coming into her office, small office, Miss James is sitting down, he's sort of standing over her, full uniform, armed. In our view, it presents kind of a clear picture of an intent to retaliate, to intimidate.
Do we know what he's been doing that day? Do we know where he's been? Do we know why? Is it in the record that he's normally supervising her without not in uniform?
I believe that is in the record. I think respondents have said that he had some meeting that day, and that is why. But we have also put.
That would be a reasonable explanation, would it not?
Yeah, I mean, that is their position.
Thank you.
I just have some questions about how you get to a discussion of pretext at all. The burden didn't shift in the investigator's report to the complainant to explain the pretext, did it? I mean, the investigator didn't find an adverse employment act or retaliation at all. And so you don't need it. You keep talking about the dissembling nature of the reply, but there's no, you don't get an opportunity to raise pretext because the investigator, if you take the investigator's facts as true, his investigator found that even the things that the respondent's employee was accused of doing didn't rise to the level of harassment.
Right. I think that's where the first part of my argument comes in, that viewed as a whole instead of as individual discrete acts of retaliation, this amounts to a retaliatory hostile work environment that would meet the prima facie case. It would then go to the employer's explanation, which they have offered of why these retaliatory acts took place. And we would get to the pretext stage, the evidence I just presented on that.
And that does happen in the report, Jeff, just to let you know, if you look at page 4, paragraph 5, a prima facie case is pretty easy. So it just says that she was allegedly subjected to an adverse employment action, criticized during her evaluation, even though it was positive on paper. So we got her to the final analysis stage where they would talk about pretext.
I guess. All right, I guess I understand that. I
I'm
don't.
just saying that's why
No.
we're talking about it, not.
Thank you.
Any other commissioner questions for Attorney Beard? All right, seeing none, you'll have about 2.5 minutes to take them back. Attorney Carter. You have 10 minutes. Do you want to reserve any of that time?
I'll just reserve whatever I have left, if that's all right.
Go ahead, whenever you're ready.
Good morning. My name is Jeremy Carter. I'm an Assistant Attorney General with the Litigation Division. And I represent the Maine State Police, and I'm asking you today to adopt the investigator's report and recommendation of no reasonable grounds. As was alluded to briefly there by Commissioner Ashby in his question, this case doesn't get to the level of much further analysis beyond whether or not adverse employment actions took place. Investigator Beauchesne did a thorough investigation. There was a fact-finding conference, and it was found that for every claimed instance of adverse employment action that was supposedly retaliatory or discriminatory, there was a legitimate non-discriminatory reason. Now, the initial sort of things you might look for in an adverse employment action retaliatory case, like demotion, firing, a change of hours, a change of pay, a stripping of supervisory responsibility, even a series of negative performance reviews. None of those are present in this case. Ms. James did not lose any pay. She did not lose supervisory responsibilities. Her schedule wasn't changed. She wasn't demoted. She wasn't fired. And as has been said, and as was demonstrated by the report, she received an overwhelmingly exceeds expectations performance review. Absent those traditional sort of more custom or perhaps more expected forms of adverse employment action, Ms. James and her counsel have focused on smaller instances that took place in between Lieutenant Zabarski and herself in the office that she claimed were unpleasant and were hostile. And Investigator Beauchesne rightly went through, we think, each one of those and sort of realized and commented how they didn't rise to the level of retaliation because they were very easily explained. She claimed that in her performance review, she was yelled at, that he was very hostile, that he was very angry. Well, Lieutenant Zabarski claims that that's not true. He says that it was a normal performance review he would give to anyone. So what we have there is one side says one thing, the other side says the other thing. The only objective evidence we have about what that performance review entailed is the paper performance review, which, as has been stated, was overwhelmingly positive and quite complimentary of Miss James. As Investigator Beauchesne noted, that would have been a place he could have retaliated against her if he had been so inclined to do. It doesn't exist. She even went so far as to say, oh, I disagree with some aspects of this, and I'd like to make corrections. And Lieutenant Zabarski obliged. He went along, he made those corrections. I believe Commissioner David raised it, and I would like to raise it here as well. It is occasionally necessary for a state trooper like Lieutenant Zabarski, even if he isn't normally out on the road, to wear his uniform and wear his service weapon, even in the office, doing his day-to-day management obligations. To suggest that that was some kind of threat, to suggest that that was some kind of intimidation tactic, that's really quite an insult to Lieutenant Zabarski, who has honorably served the state police for many, many years. He's a decorated veteran of the force. And Miss James knows well that that wasn't an intimidation tactic. She's worked in that office before for many, many years. She knows that sometimes police officers have to wear their uniform. And again, as Commissioner David pointed out, there was no, Commissioner Zabarski explained in the fact finding that he had had an obligation earlier that day that required him to wear his uniform that day. That's all. To try and infer some nefarious intent from the way he dressed that day is unfounded and really quite unfair to Lieutenant Zabarski. As to the other instances that they have cited, Attorney Beard said that if you take them all as a whole, it creates a hostile work environment. But if you look at them, they really don't rise to the level of being very serious. And that's what Investigator Beauchesne found. She claims that she was left off calendars and left off team leader discussions. But there's really no evidence as to what that really even meant for her. She doesn't claim, at least as far as we're aware, that she missed out on any opportunities, that she didn't have the information she needed to do her job. And again, Lieutenant Zabarski denies this. He's not really sure what she's talking about there in terms of not being on the right calendars. At another point, they claim that he referenced her potential retirement and that this was some sort of hostile retaliatory action. It wasn't. That document, viewed in its proper context, was clearly Lieutenant Zabarski as a manager engaging in long-term planning for his department. Miss James will be eligible for retirement in the not too distant future. And if she does choose to retire, he'll have to decide how to proceed with filling her vacancy or perhaps even applying for a second one. Ms. James has claimed that he's refused to interact with her. And again, Investigator Beauchesne found that there was a very reasonable explanation for this. A complaint had been filed against Lieutenant Zabarski, and to the extent there might have been a more limited interaction between them, that is an innocent enough explanation that he didn't want to agitate a situation further that was in the process of being resolved before this commission. Finally, this accusation that Lieutenant Zabarski told some other member of staff that you can't trust Miss James, Investigator Beauchesne rightly noted that that's not supported anywhere by the record. At no point, even in the confidential fact finding, did Miss James reveal who that supposed person was. Who said that to her? Who told her that he said that to her? The name has never come up. We don't know who it is. There's no evidence whatsoever to support that that ever happened. So if you want to take all of these things together, as Attorney Beard has recommended you do, you still don't really rise to the level of anything retaliatory. They are all easily explained, and in the pretextual situation, that's only rebuttable if there's not a legitimate non-retaliatory reason for these things offered. There was to the satisfaction of Investigator Beauchesne, which is why an investigation into pretext didn't go much further. To claim that Lieutenant Zabarski said something inconsistent in fact finding versus what he said in his written submissions to this commission, that doesn't give rise to pretext that he's lying about anything. Attorney Beard couldn't point to anything really specific about how this process unfolded that he lied about. Lieutenant Zabarski has made it clear through the fact finding and through previous submissions, as we have through ours as the Maine State Police, that he's eager to work with Ms. James as a manager in the best way they can going forward. That has at times been difficult given the nature of what's happening here and Ms. James's overall attitude toward him, but there has never been retaliatory intent. There has never been discrimination against her for filing a complaint. There has never been any sort of thing that would rise to the level of a severe or pervasive hostile work environment. The things Ms. James complains about are largely management. It's Lieutenant Zabarski trying to run his department and manage it as best as he can, given the circumstances, and trying to be respectful of the process that is unfolding here. I'm happy to take the commissioner's questions if there are any.
Commissioner, questions for Attorney Carter? Commissioner Douglas?
Yes, good morning, Attorney
Good morning.
Carter. Yeah, I was just looking at the report here. In terms of the alleged acts of retaliation, and I wanted you to speak a little bit on the omission from the team calendar. I mean, you've described sort of typical adverse employment actions as involving, and I think you're right, involving a firing or demotion, loss in pay, things of this nature. Isn't sort of an omission from a team calendar that you were previously part of this, that sort of go down that road? And just, if you could just address that briefly, I'd appreciate it.
Well, I suppose if there was some evidence to suggest that it was done intentionally to deprive her of information she needed to do her job, you could perhaps make the argument that that was an adverse action. But there's simply no evidence here. Ms. James has not offered any to suggest how this, first of all, Lieutenant Zabarski isn't, as far as I recall, not entirely sure what she means by this, what team calendar she was left off, and to the extent that he did it purposefully, there's even less evidence. If it did happen, if there was an omission, the suggestion that he did so purposefully, retaliatorily, or maliciously, that's totally absent as well. So I suppose there is a world where leaving someone off a team calendar could potentially be an adverse action, but there's simply no evidence here to support that it was. There's no evidence she lost out on anything. There's no evidence that she wasn't, given the information she needed to do her job. And there's certainly no evidence that if she was at some point left off a team calendar, that it was done with any intent.
Thank you.
Any other commissioner questions for Attorney Carter? Seeing none, Attorney Carter, you'll have about 3 minutes when we come back to you.
Thank you.
Attorney Yule?
Thank you. Good morning, commissioners. My name is Eric Yule. I'm here today representing Lieutenant Mike Zabarski, who's in the meeting with us today. Let me just start out by saying, please, that Lieutenant Zabarski takes great umbrage against the personal attacks that have been made to him in this case. In the presentation today and in the written submission, saying that he is dishonest, untruthful, and misogynistic is simply not true. They're false comments, they're defamatory comments, and they're gratuitous. Oftentimes we see in cases when someone doesn't have facts, they resort to name calling, and that's what's going on here. It underscores really the total lack of evidence to support a claim of retaliation in this case. Just as the investigator found, this is a case with unsupported allegations and no viable claims. The alleged untruthful conduct that Lieutenant Zabarski made was that he said he didn't subject her to a bad performance evaluation. And that's true. Asking someone, your subordinate, to come to me before you criticize someone that's not a bad performance evaluation. That's not lying. That's not being untruthful. That's a gratuitous comment. Lieutenant Zabarski, a decorated veteran with 22 years in the Maine State Police, 12 years as a respected supervisor. He was an attorney before he joined the Maine State Police. He served as a court-appointed guardian ad litem. He has a long career of public service with an impeccable reputation. He works hard every day, striving to do the best he can to help his coworkers and the public. During his career, Lieutenant Zabarski has consistently helped and mentored colleagues and coworkers through difficult times, and he just deserves better than this. The things that are being said about him simply are not true. The investigator's report fully supports the absence of any facts to show retaliation. As Jeremy was pointing out, this laundry list of items that supposedly amount to retaliation first of all, simply are not true, and together don't rise to the level of a hostile work environment, which is a very high standard. The commissioner asked about the question of the Teams calendar. Lieutenant Zabarski didn't even know that he had a Teams calendar. Apparently, people can put their name in and ask to be part of their calendar so you can look at it. He didn't even know there was such a thing. He's, not exactly a real big computer guy, right? So he had no knowledge of that. He didn't exclude her from meetings. He didn't refuse to communicate with her. In fact, just the opposite is true. Lieutenant Zabarski, there's not even anything to retaliate against Lieutenant Zabarski, against the complainant here. He cooperated in the investigation. Human Resources said that he and the sergeant did everything that they should have done to support the officer's claim. He went to her, said, is there anything I can do? If you need to report it to HR, that's absolutely what you should do. The complainant pushed the complaint, and she herself didn't report it to Human Resources, even though she had an obligation to do so. In the end, Lieutenant Zabarski completely cooperated in the investigation. There wasn't even anything that happened that was to retaliate against. The complainant sent an email saying that the officer, who supposedly was subjected to the sexual harassment, was disappointed with the way that the sergeant handled the matter. So Lieutenant Zabarski simply said, hey, if you've got a complaint about a staff member, come to me as your supervisor, talk about it. That's not retaliation. That's not hostility. That's not a hostile work environment. And he also offered, the sergeant and Lieutenant Zabarski offered to meet with the complainant to talk about the complaint, but she refused to. She didn't want to talk to him. She didn't want to have anything to do with them to cooperate with reporting this complaint to Human Resources. There simply was no retaliation in this case. There was no discipline, there was no demotion, there was no reduction in pay, there was no termination, there's no disciplinary action, no negative evaluation. In fact, Lieutenant Zabarski, as is noted, gave the complainant exceeds expectations on a performance evaluation. That's hardly the act of someone who's looking to retaliate against someone. If Lieutenant Zabarski wanted to retaliate against the complainant, that would have been a great opportunity to give her a negative performance evaluation and try to evaluate her out of a position or a demotion, but he didn't. He didn't do that. He's cooperated. He's given her positive performance evaluations. He's tried to work with her. He's tried to be a good supervisor, but I think that the truth of the matter is this is someone that just does not want to be supervised by Lieutenant Zabarski. Lieutenant Zabarski had no problems with reporting harassment, as I said. He encouraged the officer to do what she needed to do, and he talked to her to make sure everything was okay. So he wasn't trying to cover up harassment. He wasn't trying to cover up the complaint. The only thing that he did was ask the complainant to come to me if you have a complaint about one of my subordinates. That's not retaliation. That's not a hostile work environment. And Lieutenant Zabarski has been nothing but truthful and honest and forthright in all of his testimony in these entire proceedings. It's also important to emphasize that the investigator found no grounds for individual liability against Lieutenant Zabarski. As you probably know, the law court and the state courts have held that the Maine Human Rights Act does not provide for individual liability against supervisors. There's been a federal court case that has opened up the question as to whether or not interference can be an exception to that. If somebody interferes with someone's rights, that can rise to the level of personal liability. The investigator, however, found in this case that there was no evidence to show that there was retaliation or interference in Lieutenant Zabarski. In the opening footnote on the first page, it said there's no reason to evaluate that claim anymore because there's just no evidence to support individual liability in this case. So we respectfully request that the commission vote to accept the recommended finding of no reasonable grounds in this case. Thank you. I'm happy to answer any questions if you have any.
Questions for Attorney Gill?
Yeah, just repeat what you said there, that last argument about his personal responsibility. He would only be exposed if he was interfering.
Yes, so
for preventing the report or retaliating for protected activity or something like this.
right, in the law court case, the Furman case, the law court held that there's no individual supervisory liability under the Maine Human Rights Act.
Right.
First,
I was wondering why it was in here individually at all, and that's,
that's certainly a question that we have.
well, he's an employee, clearly, and so,
He's also a supervisor. We believe there's no individual supervisory liability under the Maine Human Rights Act. And even under the interference provision in a different section of the Maine Human Rights Act, you have to demonstrate that he somehow interfered with somebody's exercise of their rights under the Maine Human Rights Act. And the investigator found that that does not exist in this case.
thank you.
Any other commissioner questions for Attorney Yule? Seeing none, you'll have about 4 minutes when we come back.
Thank you so much.
All right, Attorney Beard, you have 3.5 minutes left.
So just sort of as an initial matter, I do think it's somewhat ironic that we're being criticized for leveling unfair accusations when respondents' close of evidence submission was simply a list of irrelevant insults about Ms. James's performance. Has nothing to do with this case. Regarding Lieutenant Zavarsky ostracizing Ms. James, attorneys have said that there's a reasonable explanation for that he didn't want to interact with her. But this is just legally wrong. Ostracizing an employee for making a legally protected complaint is retaliation. It's on the employer to still treat an employee properly after filing a complaint. They can't refuse to interact with them just because they feel uncomfortable with the fact that the employee filed a complaint. With the Outlook team calendar, certainly a reasonable inference can be made here that this is the same sort of thing, that respondents are excluding Ms. James because she brought forward this complaint, which clearly made Lieutenant Zavarsky upset. And this is so just to explain a little more what it was, it's an Outlook team calendar. People were added to this over time. It was a somewhat fluid thing, but complainant was never added. She was never someone who was added to this. Again, I think a reasonable inference of retaliation could be drawn there. And then lastly, just on the point of individual liability, I think a fair reading of the investigator's report here shows that essentially the investigator found that there was no individual liability, essentially for the same reason that there weren't liability against respondents overall. The report says respondent Zavarsky did not engage in any individual action amounting to retaliation or interference. I think for the same reason that we disagree with the investigator's report about retaliation in general, that there was a retaliatory hostile work environment, that would also go to individual liability against the Lieutenant Zavarsky, that there was retaliation. There was a pattern of retaliatory hostile work environment. And so we would ask the commissioners to reject essentially both findings in the investigator's report as to both respondents.
Is it correct that she did not complain to him as he complained about? The complainant didn't bring the complaint to him?
So
He's the supervisor.
right. Under the personnel policy that the state is under here, the issue was the employee whom Ms. James supervises had gone to the supervisory authorities within the crime lab.
Right.
Nothing was done with her complaint. The supervisee told Ms. James she was unhappy with how that was handled. Ms. James consulted the personnel policy, which says it needs to be reported to HR. So that's what she did. She followed the policy by doing that. Supervisor, Lieutenant Zavarsky, was already aware of the complaint, hadn't done anything with it. So Ms. James followed the personnel policy by going to HR. And then updated Lieutenant Zavarsky about what she had done and the process she had followed.
Commissioner O'Brien.
Thank you. Trying to find it, but I can't. I think we read that the employee did not want to pursue, did not want to
didn't want to do anything about it.
So, yeah, a few points on that. The employee was uncomfortable, didn't want to get someone in trouble, you know, as you often see in instances with sexual harassment. Problem here is the state policy is explicit that regardless of if the employee says, I want to press this complaint, if a supervisor knows about an instance of sexual harassment, an investigation needs to be carried out. There's very good reasons for that because, you know, for one thing, a person might be uncomfortable pressing a complaint. And an incident of harassment, sexual harassment affects more than just the person who's, you know, who was sexually harassed in this one incident. It could affect a lot of other people. So the employer here had a responsibility to investigate. The immediate supervisory authorities, when the supervisee first reported it, had not started that investigation. So Ms. James, when she found out that the investigation was not occurring, took it upon herself to report it to HR to start that process.
So I just want to get it clear. You're saying that Ms. James would be like a mandated reporter. It's in the policy that if they know about it, they need to report it. That is a written policy.
Yeah, I don't think it uses the same kind of, you know, like
Right.
social worker or
Right, right,
therapist
right.
mandated reporter thing.
Right,
But
but
that kind of idea, right. The policy says that it should be reported to HR so they can investigate it.
But you just said she took it upon herself. It's like she's talking to the victim, to the employee, who's saying that she's unhappy with what happened with her complaint so far. So complainant here, Ms. James, is saying, well, I'm going to fix this. I'm going to report it. But she didn't have an obligation to do it. She took it upon herself instead of going to her supervisor.
Right, so I do think it's right that under the policy, she was not required to or supposed to go to her supervisor. She was supposed to go to HR. So when I say took it upon herself, I mean, the issue really should have already been addressed when the supervisee first reported it to the heads of the crime lab. It wasn't, and Ms. James then followed the state policy by reporting it to HR.
Yes, so just coming back to the adverse employment action, right? I just want to make sure that I understand the allegation here. So I'm looking at page 3 of the report and it says, according to complainant, since her report, lieutenant has excluded her from email and calendar groups, refused to share information with her, referenced her potential retirement, and told another employee not to trust her. With respect to those first two things, I'm just trying to, I'm trying to figure out how she was excluded. I guess when I first read this, my understanding, or at least my presumption, was that she was previously on these groups, right? She was previously being included in certain communications in order to do her job, and that ceased once she sort of got involved in this situation. Is that accurate, or is it somewhere?
My impression is the team calendar, it was called Teams of Varsity. So I think the clear inference here is Ms. James is not included in Teams of Varsity, right? So I believe the Teams calendar started after her report of retaliation. Not that she was on it and taken off of it, but she was never included on it, never added to it when other team leaders were.
Okay. Was there, and it says refuse to share information with her. Was there any other information that was not shared with her that she needed to do her job that you want to highlight for us now?
I don't have specific examples. There are, that's one of those detailed points that is in the record. She's accused of doing certain things or not doing certain things. Ms. James' position is she was never told about those things. So it's that sort of thing. I think there was preparation for an audit or something along those lines, or Ms. James wasn't getting enough information. So those sorts of lack of communication, which sort of is a natural consequence of Lieutenants of Varsity refusing to talk to Ms. James directly, instead only communicating through sort of subordinates.
Thank you.
Commissioner O'Brien?
I bring this up only because it was brought up. What do you have to say about the fact that, I don't, again, can't see the exact words, but that she was not to be trusted and there was no witness or confirmation of that? Do you have an answer for that?
Well, I think it's a pretty reasonable thing that Ms. James didn't want to name the person who told her this, given that she faced retaliation. She doesn't want to subject another employee to retaliation. So, you know, I understand what how the investigator treated that accusation in the investigator's report. At the same time, as part of a body of evidence of retaliation here, I do think there's a reasonable inference in favor of Ms. James that, you know, this happened, this could have easily happened, even though she did not want to give up the identity of that person and subject them to further retaliation as well.
Any other questions for Attorney Beard? Seeing none, Attorney Carter, you have 3 minutes.
Thank you. Just briefly on a few of those points. As to the point about ostracizing, it is not the contention of MSP that Lieutenant Zabarski ever ostracized Miss James. That was not, if that was what Mr. Beard heard, then that was not accurate. Miss James was fully engaged as a member of the team, as someone who worked for the crime lab, as one of the many people that Lieutenant Zabarski supervises. She was not ostracized in any way. The only thing that the investigator might have rightly noted is that there may have been at times conversations that may not have lasted as long, conversations that may not have gone on as long in more sort of collegial, maybe friendly terms, because there might have been a sense on Lieutenant Zabarski's part that he wanted to give her space and allow this and be respectful to this process. But in terms of professional ostracizing, that did not happen. That is not the MSP's position. Miss James was always fully engaged by Lieutenant Zabarski so that they could both perform their duties at the Maine State Crime Lab. And just a little further, when we're talking about the body of evidence here, as Mr. Beard has, the body of evidence of retaliation, I think it really speaks to the weakness of Miss James's claim that the main thing we focused on here is calendar invites. Calendar invites that could just as easily be explained by technological illiteracy or accident or mistake as much as they could anything else. If that's the big piece of evidence that they're relying on to show that there was a severe or pervasive environment here, it really does speak, I think, to the weakness of the case and the total lack of adverse employment actions that they can meaningfully point to. Mr. Beard was just asked, what information did Miss James not receive as a result of this? And he couldn't give any specific examples. And that's exactly the point I was trying to make earlier, that even if this had happened, even if she had been inadvertently left off these lists, there's nothing to suggest that she was particularly harmed by that she couldn't do her job, or that she suffered as a result. It's very unclear as to why, if at all, she wasn't on these lists, but there's absolutely no evidence of intent or malice or damage to her. Thank you.
Any commissioner questions for Attorney Carter? Commissioner O'Brien.
Sorry, and if it's in the records, how long had they worked in this capacity together before this incident? And were there problems before this, if it's in the record?
In the record, Lieutenant Zabarski, I believe, was fairly new to the position. This happened very early on in their relationship as supervisor-supervisee. As far as I'm aware, and as far as the record indicates, I don't believe they had any problems or situations prior to this. No, he was relatively new. Mr. Ewell could speak better to that, I think, but yeah.
Thanks.
Any other commissioner questions for Attorney Carter? None. Attorney Ewell, you have 4 minutes.
Thank you.
I'll be very brief, not to beat a dead horse, but because this has been the issue, we do want to just emphasize, as Jeremy just did, that there was no ostracization. There was no withholding of evidence. In fact, just the opposite. The complainant seems to not want to share information with Lieutenant Zabarski, which makes his job very, very difficult. He did not exclude her from the team calendar. He didn't put her on and didn't take her off. He didn't put anybody on his team's calendar. He just doesn't use it. He doesn't know what it is. He doesn't use it. So he's not withholding any information from her whatsoever. And it is true that the employee did make it very clear to the sergeant and Lieutenant Zabarski, this was not a complaint that she wanted to pursue. She didn't think it was that big of a deal. She mentioned it in passing. She didn't want to pursue it. That's very, very clear in the record. And then finally, Lieutenant Zabarski was her supervisor for about 6, 7, 8 months or so before any of this happened. And certainly he's supervised her the same way. Nothing that he's done about the way he supervised her has changed in any way whatsoever. Thank you.
Commissioner questions for Attorney Yule? All right, seeing none, thank you all. We will now hear from the investigator. In this case, we're going to hear from Investigator O'Reilly because Investigator Beauchesne, lucky Investigator Beauchesne, is on vacation.
Good morning, everyone. Like it mentioned, I'm presenting this case on behalf of Investigator Beauchesne. I have read the entire record, reviewed the report, and concur to the extent that we never really don't concur, but concur with the investigator's finding and the analysis. I have a couple of things I'm just going to touch on, and then I can go into more detail if the commissioners want me to. The first is just to be very, very clear that the only issue in this case, in terms of any kind of finding of reasonable grounds, if there were a finding, would be on the issue of an adverse action suffered by complainant directly. All of the issues related to whether or not the employee who initially, was made a report of this conduct by another officer there's no standing by complainant to bring any claims on behalf of that, even if that report had been handled poorly, even if people didn't report the way they were supposed to, even if something adverse had happened to that employee. That's not relevant to whether or not complainant has any standing of a retaliation claim. So I just want to make sure that we're focused on that issue specifically. And then to go to the adverse action, the definition of adverse actions on page 4 in paragraph 3, in order to establish that an adverse action occurred in this case, it must be material, that's in quotes, which means that the employer's actions must be harmful to the point that they could well dissuade a reasonable worker from making or supporting a charge of discrimination. So whether or not those actions were taken, either each discrete action or taken as a whole, that's the standard we're working with. And then based on my reading of the report and the analysis that was done, I would argue that it wasn't that the instances were taken discreetly and therefore not analyzed as a whole in terms of establishing a hostile work environment. A hostile work environment would constitute an adverse action, and those terms don't appear in the report. But based on the analysis that was done, each individual action itself was found to not be characterized to the level that complainant asserted it was. Each individual action. So I can talk more about that as to whether or not that would have established a pervasive standard, but basically all the adverse actions were not adverse. Even if they had all been taken together, they still would not have risen to the level, if that were explicitly stated in the report, that these actions all taken together still would not have risen to the level of an adverse action. So I just want to clarify that, since that was the contention brought up by Attorney Beard. My reading of the report is that it still would have not risen to that level, despite that explicit analysis not being done in the report. And I'm happy to answer any additional questions.
Thanks, Jane. Any commissioner questions for Investigator O'Reilly? Seeing none, thank you, Jane. So we've heard from the parties and the investigator. At this time, we'll be looking for a motion. There's one proposed finding.
Oh. I move that to accept the report. There are no reasonable grounds to believe that the police and Lieutenant Michael Zabarski unlawfully retaliated against Kimberly James for engaging in MHRA and/or WPA protected activity, and the complaint should be dismissed.
Second.
Second.
Okay, it's been moved and seconded. Any discussion?
Yeah, I'll just say that, I agree with the investigator. The issue with this case is the lack of adverse employment action. I think that Lieutenant Zabarski is entitled to state his opinion about how he wants things to go, but I think that the positive job review and the fact that Lieutenant, certain extent expressing how he wants discrimination cases to be presented in the future, not necessarily saying, don't present them. I think that taken with the other allegations, I just don't think there's an adverse employment action here.
Discussion?
I concur. And it stretches credulity to say that there's discriminatory animus and that he's conniving to make all these individual things just below the level of being very serious, but that in total, he's designed a way to retaliate against him. I can't find that's credible.
Any other discussion? Seeing none, the motion is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
So the findings are no reasonable grounds. We appreciate everybody's participation. Thank you all for being here. And the commission will send a letter to the parties and council confirming the results of the hearing.
All right, our next case is ED 22-0002. That's Jonah Austin versus Hebron Academy. This is a reasonable grounds case. We should hear from the respondent. Hebron Academy or its representative. By definition, it's representative.
I believe Hebron Academy is represented by Attorney Walker.
Yes. Can I?
Just a minute, Tara. Chelsea's just pinning you to the screen.
Okay.
Okay. Do you want to reserve any time?
Yes, please. 3 minutes if I could, please.
Sorry, did you say 2 or 3?
3.
Okay. All right. Go ahead whenever you're ready.
Great. I am Tara Walker. I'm joined also by co-counsel Ron Schneider of Bernstein Sure, both of us, and we are outside counsel to Hebron Academy. Here with us on the Zoom as well is Patrick Phillips, who is the head of school for Hebron Academy. So as noted in our written submission, there are several factual errors and chiefly one legal error that led to an erroneous outcome in this case with the investigation report. But in thinking about this case and thinking about coming before you and stepping back, I took one 30,000-foot view of what happened in this case and thought to myself, if we did credit the investigation's findings, and I had to go back and tell Hebron Academy what they should have done differently in this case to follow legal obligations, not to discriminate against a student applicant who's expressing mental health needs. I think the only fair answer to that question or to that advice is not one single thing should they have done differently to follow their legal obligations. And this cuts to the core of the misunderstandings and the mistakes that affected the outcome of the investigation report. Ultimately, when I look at the conclusion, the investigator has stated that the complainant would not have suffered revocation but for his disability. I mean, this misapprehends the whole nature of this process. At all times, we can talk about all the things that I think there is agreement on, or there should be largely agreement on. We all agree that Hebron Academy should have a process by which it determines whether it can accommodate student applicants who have expressed these kinds of needs, right? That's basic. That it is a private school. It is not a public school that receives federal funding for the purposes of providing these exact accommodations. We don't have the ADEA. We don't have 504 plans. We don't have that process here as a private school. So they're limited in what they can offer based on what programs they have. We also agree that nobody can make the determination about whether Hebron Academy can accommodate a student applicant other than Hebron Academy. not the therapist, not providers, nobody else. It's really up to the school, knowing its programs, its staffing, the nature of the school itself, to make a determination on whether it has sufficient resources to meet the needs and to identify the needs of the student. And that nobody wants to admit a student to a school where it cannot meet those needs. That would be unsafe and unfair for the complainant to do that, as well as unfair to the staff members who are not capable, based on the structure of that program, to meet the needs that have been identified. And we agree that probably there are some students, inevitably, there will be some students that apply that we cannot meet the needs for. So really, what this comes down to is, what is the process? In order to make that determination, we again all agree that it cannot be done on the basis of stereotyping. We should not be, our process should not rely on making assumptions about someone's medical conditions or what their needs are. And the evidence in the record is very clear that that is not at all what happened, not counting any of the email exchanges that occurred in this case. After complainant had submitted his application through the educational consultant, there were at least 4 separate conversations with various members of the team on admissions and the health department. We had student admissions, and detailed conversations with the complainant's treating therapist, with the staff and counselors from the prior therapeutic school with whom he had been enrolled before applying to Hebron Academy, with his parents, with the educational consultant. They sought detailed information and obtained detailed information about the complainant's conditions and his needs. That's the purpose of those conversations. It's to have an iterative conversation about identifying the particular types of needs that he would have if he were to attend Hebron Academy, and whether the staff could provide that, given the resources that they have. Where it appears we do not agree is whether Hebron Academy was in fact correct when it said that it could not accommodate the student's needs. Did it make the correct decision? And there's just one point that I have to make from the outset, and that's clear in the case law. It's clear from the structure of this, that absent affirmative evidence of intentional discrimination, Hebron Academy's own decision about whether it could accommodate an applicant student is entitled to deference. They don't get to, we're all familiar, I think more commonly in the employment context, that courts say they don't act as super personnel departments. We're not going to put ourselves in your shoes and retread your decisions. I would say that the standard in the educational context is one step higher than that. You really do need affirmative evidence of intentional discrimination to have occurred before you can step into the shoes of the school and make that determination for them. So we start with that baseline assumption that courts and the commission should be reticent to disturb the decisions of an educational institution. And here, what we found is that decision was made based on the factual evidence, detailed conversations that happened with the providers. And I think the evidence in the record contains several factual errors and misapplications of the fact that led to an erroneous result.
Attorney Walker, that's 7 minutes.
Oh my goodness, that went fast. Great.
All right.
I'll reserve the bell.
Okay. Any questions for Attorney Walker? Commissioner O'Brien.
Somehow I can't open the case, but as I recall, and correct me if I'm wrong, I'm sure, this was a very long process. And if I, again, recall, he was conditionally accepted and then went through all these hoops. And then at the end, did not get accepted, or it was withdrawn. And the school did not let him know that. It was through a third party. And I'll hold on to that. No, I won't. The other thing is, did Hebron Academy reject the application solely? Not solely. The report kept referring to potential of his taking his own life by taking the alcohol. He had done, that he had done before, and it was accessible. Well, I just remember in reading this again, that any student, that can happen with any student. If it's the suicide, and I know this is very hard to talk about, but if it's the suicide issue, is it? Well, is it, I guess I would leave it at that. Sorry, that's a lot of questions, a lot of garble, but.
No problem. I'll answer those in the order that you asked
Yep.
them. I think it makes sense to do that. This is one of the fundamental errors of fact that I was about to mention, is the nature of the conditions of enrollment. It was viewed in the investigation report as though the presentation to the parents and Hebron Academy's position is, if you complete, steps A, B, and C, automatically you will be enrolled and we will accept you. And that is not the case. I think perhaps this would have been better clarified had we had a fact finding or an issues and resolutions conference in this case, where that could have been better fleshed out. But always, at all times, Hebron is evaluating the information that it's receiving from these sources. And constantly, I think it can't be overstated the nature of the detailed conversations that they have. There's a lot happening in these conversations, right? So some of the staff members will say, well, what about this idea? What about, I'll give an example. What about body checks, right? Because self-harm was identified as one of the accommodations or needs that may require an accommodation. So one possible accommodation is doing body checks to check to see if complainant's condition is manifesting in that would suggest further intervention is needed. That would be a need. The family declines those. That is their right. We respect that decision. That's their decision. But that's one, possible iteration of accommodations that get floated in these conversations. So although there are conditions, this is part of a comprehensive discussion that happens in the beginning. They say, we want to see the following things happen. Indeed, one of them was this summer program. That was actually a recommendation by his own therapist, not by Hebron Academy. Follow your therapist's recommendations was what they said. And if you do those things, we still consider your needs. We still consider whether we can provide for you based on those identified needs. That never goes away. So I think the assumption that has he done A, B, and C, that he would automatically be enrolled is one of the fundamental flaws. They did not communicate directly with the student or the family because about the enrollment decision, and ultimately the decision to deny enrollment and to say that they could not accommodate their needs, because everything had been communicated up until that point, other than the interview with the parents, through the educational consultant that was hired by this family. So that communication occurred to the educational consultant as well. And lastly, your question here is, what was the basis? Essentially, what was the decision? Was this a long process, and was it ultimately the potential risk that he may commit suicide? That was the basis for the decision. And not exactly is my answer to that question. The decision was based on the fact that Hebron Academy felt that it could not meet the needs of this particular student, given its environment, based on the new information that they learned. For example, that he had made, one of the things that's mentioned is this neuropsychological evaluation. Didn't you have everything you needed to make a determination about whether you could accommodate the student based on the neuropsychological evaluation that you had back in March. That was a complainant's assertion that also made it into the investigation report. That neuropsychological evaluation is not in evidence, but I will say this, no is the answer. It did not contain very detailed information about complainant's condition, including that he experiences hallucinations, command hallucinations that have him, instruct him to harm himself, and that he had prior attempts with a common ingredient, isopropyl alcohol, common ingredient that is ubiquitous. This is 2021, ubiquitous throughout Hebron Academy's campus because it's the ingredient in hand sanitizer. Now, we know the pandemic, right? You had to put hand sanitizer everywhere. And even though it's called alcohol, isopropyl alcohol, that is not regular alcohol. It is lethal substance. And so, these are some of the factors that the staff began to learn in these detailed conversations that led them to the ultimate determination through the student admissions committee that they could not accommodate all of these needs. It was difficult to tell when his condition was worsening or when he was decompensating, because the only indication they got was that he may raise his eyebrows, but not his eyes.
Attorney Walker?
Yeah.
I feel like we're getting into argument here as opposed to just answering the commissioner's questions.
Yeah.
I do want to be mindful of time here. Any other commissioner questions for Attorney Walker?
Yeah.
Commissioner Douglas,
Yeah.
and Commissioner David.
Yes, Attorney Walker, good morning.
Morning.
Yeah, so I'm just looking at the report in reference to your comments about the neuropsych eval. So if we look at paragraph 7A, I'm just going to read it to you. It says, first, consultant provided respondent with complainant's full neuropsychological evaluation in January 2021, which contained information about complainant's past suicide attempt and the triggers that led to it. Do you agree with that? I mean, is that accurate?
No, that is inaccurate. It's specifically the reference to triggers. The triggers are not in the neuropsychological evaluation. The means, the triggers, and then information regarding past attempts. I don't know why they were not mentioned. The employee identified in the investigation report as health did not know why they weren't mentioned, but they just simply weren't present in there.
Okay, thank you.
Commissioner David.
Well, as I read this, Attorney Walker, they go through, as Commissioner O'Brien pointed out, a long process. They indicate that they understand the situation. They're reviewing medical reports. They impose requirements of counseling and a specific course, and he complies with all of those things. They tell him, to my mind, they tell him he's accepted. You take $60,000 from him, and you're saying, well, that's not acceptance. We still have our fingers crossed. And it comes down to what they say. What you say is that the student support team made a decision. Do we have that decision? Is that in writing? Is that in the record?
There's not a written decision that comes out of the student support team. No, there's just the meeting and the information that came from the participants on that committee. And
those participants are different from maybe different from the whole other bureaucracy that was accepting him and imposing requirements and saying this is what you got to do, and yes, we'll take your money and you're in.
There's one point in there where I would disagree with you, and that is essentially it is the same composition of people. So a lot of the people who are having conversations with the therapists are also those who are participating on the committee. And I think the distinction is that it got to the late conversations that were happening in July, where new information was gleaned that led to the decision not to enroll complainants. And the very fact that it took so much effort and time, that the conditional enrollment is to me irrefutable proof that there is no discrimination here. How could we possibly call that decision discriminatory on the basis of any disability when they've taken so much time and effort to try to accommodate him. Always, Hebron Academy has the right and the obligation to determine what accommodations it can provide. And it's that information in July that I was just starting to get to. I don't want to stray back into argument, but the new details in July that they're learning about that led to ultimately to the student committee's decision not to enroll him.
I couldn't find any significant new information. The suicide is there previously, the self-harm is there previously, the need for mental health support is there. It just seems as though, as you say, there's no written decision. We can't look at the student support team's change of heart. Somebody had a different opinion based on his disability and said, no, I recommend that we don't take him when we can't support his needs. And at that point, it seems to be it's discrimination based on his disability.
Our position statement does outline I think we listed 7 new details. Let me just summarize this in 3. It's the prior attempts using the isopropyl alcohol, which was not something that they could control for. It was the decompensation, the fact that from the therapist and the parents, that when his condition was worsening, he didn't share that information with parents. He was not open, and that it was very difficult to tell. And it was confirmation that he had indicated with 100% certainty that he would end his life in the future. I think those were the key new details that the committee relied on. There are others, and I don't go into all of them here, but they are outlined in our position statement.
Yeah. Okay.
Any other commissioner questions for Attorney Walker? We'll still have 3 minutes when we come back to you, Attorney O'Meara. 10 minutes. Did you want to reserve any of your time?
Whatever left, thanks. Morning, Commissioners. Richard O'Meara on behalf of Jonah Austin, who's now 20 years old and in college. And I want to address first the framework in which you list the case, because I think Attorney Walker is trying to get you down to a path you shouldn't be on. This is not a case where a student came to a school and requested accommodation, which under your statute 4592 would put you in Part B. This is a case where a student came with an application for admission. And Part A says in that statute that you can't impose eligibility criteria that tend to screen out individuals with disabilities or any class of individuals with disabilities from fully and equally enjoying the goods and services and facilities and privileges of the school. So this is an admission case. How do you get into a school? And Jonah met all of the requirements. He had the academic background for the PG year. He had the money. He signed an enrollment contract. And yet Hebron conditioned his admission on doing some things that were exactly related to his mental health struggles. Now, you have to keep in mind that the mental health struggles that Attorney Walker is talking about happened in 2020 during the summertime, which is when the suicide attempt occurred. Since that time, he had been treated. He'd been inpatient at a hospital. He had done several months at Newport Academy, which is a residential facility, and he had returned to his high school, finished high school, fully treated. And then there was a discussion about we will not accept him unless he does a DBT program before he comes. And then he went into the McLean program.
Attorney O'Meara, please don't mention the names of the facilities.
Okay. He was placed in a summer DBT program that his counselor recommended, yes. But that was at Hebron's insistence. And you'll see, it's in the record, there is an email at the time he was accepted back in January and February of 2021. This was one of the conditions that Hebron placed on him coming there. This was an extra hurdle he had to go over as a condition because he was a student with a disability. We don't think that should be there. And in fact, the investigator in the report suggests, and I tend to agree with this, that the respondents' reasons, these conditions themselves are discriminatory because they're based upon the behavioral symptoms of his disability. In other words, even after being treated he was still being treated by the school as if he hadn't been treated, that he was still an active suicide risk. They had to watch him at every moment. And that's a stereotyping based on mental health disability. So we believe that the conditions being placed themselves are discriminatory. And the arguments made here by Hebron that we get to put the conditions on kids with disabilities about how we want them to be when they come to us. And I think what they're asking here for you to do is give them complete discretion to do whatever they want to do. In this case, kind of proves it, because as the investigator says, they set out the things that were the conditions and then changed them as time went on, because the three conditions placed at the beginning were go to a summer DBT program, make sure you're on medication management when you come here, and make sure you're in therapy when you come here. The student agreed to all these and they paid their money. They had the enrollment agreement, which does not say anything about these conditions. Those were all done by side emails. And then once he has completed the summer program, and perhaps Hebron thought he couldn't do that. Maybe that was the gamble here. I think back to the Wizard of Oz, right? What's the condition? That I'll help you get back to Kansas, Dorothy? Go get me the witch's broomstick and bring it back. It's one of those conditions that's like, this will never happen, right? And when it happens, the wizard's flummoxed, doesn't know what to do. Oh, now what am I gonna do? Think of something else. That's sort of what happens here. Can he actually go to a summer program and complete it? Yes, he does. It's $16,000 and 3 weeks of work, and he does it successfully. And then they have to come up with some other reason to try to deny him. And that's all the stuff we've heard now that all go back to 2020, all evidence that they already knew or should have known about his condition. And so when you look at this case, the investigator has it spot on. The reasons of the conditions were discriminatory. And then when they didn't even follow those conditions and tried to impose more hurdles for the student to come to their school, that's further discrimination. And it's not a case where the student ever asked for any accommodation at all. There was no accommodation request made. It was an admission request. Let me into your school. And you should know the student did go to a different school for his PG year with no accommodations and succeeded. He's now in college. So this is a stereotyping case. It's one where the investigator has it right, and you should all vote on supporting the investigator's report that there are reasonable grounds here to believe that discrimination occurred. And I'm happy to take questions.
Commissioner, questions for Attorney O'Mara? Yes, Commissioner O'Brien.
Thank you. I just keep going back to the fear of him taking his own life. And just to be clear, the school has no liability for that, correct? I mean, again, suicide happens with no triggers. So the liability, that's, I guess, what I'd like to know. Is there any, would there be any liability?
I can't think of any on this. I mean, unless the school has done something actively to encourage it, but I don't see that happening. Just by being in the school does not make them responsible for his life if he decides to take it.
Sure does.
Good morning, Attorney O'Meara. Yeah, I understand where you would like our focus to be here. Attorney Walker, her position appears to be in her objection that there's all this new information that came out early January. The school didn't know, and that sort of changed their perspective on all this. Can you just briefly address that? Because what I'm specifically curious about is what, from your perspective, what was new in July, if anything? Or did they already know all this?
I think they knew everything. I mean, it wasn't in January is when all the information came from the consultant to the school and the emails and the record of what the three conditions were at that time. All right. In July, there were more interviews with the parents and with the healthcare providers, both the outside therapist and the therapist from the summer program. But there's no significant new information that came out then. She mentions the isopropyl alcohol, and like a big so what? That was from 2020, and that was part of the prior suicide attempt. And if they wanted to look into the level of detail as to exactly what products were used, they could have done that in January. But instead, they offered admission, and they offered it with those 3 conditions in the email and an enrollment agreement that had no conditions. So there's really nothing new that came out in July that should have changed this. And even if it were, if it's based again on the disability, we think that's discriminatory anyway.
Thank you.
Any other commissioner questions for Attorney O'Mara? Seeing none, you'll have about 4.5 minutes.
Thank you.
Attorney Walker, you have 3 minutes.
Yeah, I just want to address 2 very specific assertions that Attorney O'Meara just made that are contradicted in the record. The first is the assertion that Hebron Academy somehow, and this is out of nowhere in the record, asserted that he should attend the summer therapeutic program as a condition that they knew he could not meet. Frankly, that is offensive. The record states that based on the conversation with the therapist, that complainant returned home from his prior school in the prior academic year, and it was decided with the family, this is a quote, with the family and, I'm paraphrasing, consultant, the educational consultant, that he needed more intensive treatment. This summer, he will be in counseling at the summer program. Although Hebron Academy did include that as a condition, that was not our suggestion. That was not a condition we created as a roadblock of any kind. That was a program identified by complainant's own family and complainant's own therapists that he should attend. So that is just false. The other falsity that Attorney O'Meara just mentioned is essentially that there were no new facts and no new information. There is also emails exchanged with the consultant in the record that it demonstrate that it took the consultant a very long time to get back to Hebron Academy staff's request for information, and getting a therapeutic history and I'm speaking with the complainant's therapist is very much a part of this, not because we're making stereotypes, but because the consultant was specifically engaged with us to identify safe and appropriate accommodations that would help him thrive in this environment. These are not conditions we're imposing unilaterally. These are coming from his own providers. That is not a stereotype case. Full stop. It is entirely a case where the information the obligations we have to comply with under the Maine Human Rights Act is to get this information and ensure that we can accommodate it. Those were coming from his providers. It was new information. She did not respond back until June. That was what the delay was, and why all of these conversations happened in July, which, by the way, these staff did during the off season when they're typically on summer. So they're having these conversations, and I think the record is quite replete with information that was entirely new. There's no basis to say that he did not need any accommodations. That's just wrong.
That is your time. Any commissioner questions for Attorney Walker? Seeing none, thank you, Attorney Walker. Attorney O'Mara, you have 4.5 minutes if you have anything else you'd like to add.
There's very little left to say. I just want to give you the timeline so you have it. January 15th, when the application, or the consultant talks about application and provides the neuropsychological evaluation from the Newport Academy. 2/26, there's an email from Hebron confirming that he would be admitted with the conditions, including the residential program in the summer. That was
January 26th?
February 26th. So Attorney Walker can say that the counselors wanted him to go to that. Hebron made it a condition of his admission that he go to that program. It's in an email from February 26th. March 6th is the acceptance email, which is referenced in the report from the Director of Admissions saying you're admitted. The enrollment contract was signed March 29th. It does not say conditional. It was signed and the deposit was paid. In May 14th, the $60,000 tuition payment was made. June 7th to the 28th, he actually completed the summer program at the DBT program we talked about. And then everything starts after that, July into early August, when the decision to admit is revoked. And so all the conditions were met as of June 28th, and then Heber went through the machinations to make this not happen. That's the timeline we have. I'm happy to take other questions.
Any other questions for Attorney Munro? Thank you very much. Great. We'll next hear from Investigator Hurd.
All right, good morning, commissioners. As you know, I'm Colin Hurd. I was the investigator on this case. So a few things I wanted to point out. So for me, you know, the crux of this case kind of started with that February 26th email. And then just to be fully transparent here, I'm going to read the piece of that email that's in the report. So this was an email from health to consultant. It says, to confirm, we have counseling, medication management, and completion of program as conditions for his enrollment. If the family wants to hold the spot, they can sign the contract, pay the deposit, and hopefully complainant will come in September. However, if he does not complete the program or the therapist does not recommend a placement like Hebron, we would not hold them to the contract and refund their deposit. So that email to me seemed to pretty clearly state that complainant's enrollment was conditional upon completion of those things. Complainant met those conditions, and then, you know, as you know, on August 1st was when the student, I forget what it was called, it was the student support committee or student support team met, which also was just, I think, a month before school started, and made the decision to revoke that enrollment. So the respondents say that the revocation was based on the learning of new and crucial information. Complainant provided evidence that the neurological report had been emailed to them on January 15th. I did not read that report. I didn't think I would understand it if I did read it, but complainant provided evidence that they had sent it to them. I have the email with the attachment on the bottom. Presumably somebody had read at least looked at that report before coming up with the conditions that complainant needed for enrollment. I understand that respondent is saying that some of those were based on suggestions from complainant's own therapist, but based on that email, they seem to accept those suggestions and to incorporate those as conditions. This next sentence, I want to be clear, is speculation on my part, but it seemed more likely to me what happened was that some members of the student support team that made that final decision, maybe they didn't know the full record or they didn't have all the information until that day. And that's what led them to make the decision that they could not accommodate complainant. I think that the report lays out pretty well why I think, at least, that the reasons that respondent gave were pretextual. I think it's pretty straightforward, but one of the things the report does not say that I think I would like to emphasize is that the troubles that respondent highlights, and one of the commissioners kind of talked about this a little bit in her questions, as reasons why it would not be safe for respondent to take on complainant are not problems specific to complainant or even to his disabilities. You know, the potential for students to be withdrawn, to not tell adults how they're feeling, to abuse over-the-counter substances and isopropyl alcohol and whatnot, to be stressed out, not get enough sleep. These are things that all teenagers go through and all students go through, especially in an environment, in a dormitory. So the only thing that really separated complainant from all these other students is the fact of his disability and respondent's knowledge of his disability and the symptoms of it. That's ultimately why why I came to the conclusion I came to. So that's all I have, and I'm open to any questions you may have for me.
Commissioner, questions for Investigator Hurd. Commissioner Ashby.
Thank you. This is not a question. It's just an observation, Investigator Hurd. This is an extremely well done investigation and report. And I want to thank you for it. It was very helpful to me. It was thorough and it's a lot of facts. I zeroed in also on the February 26th email, and your setting forth that language is really helpful and clear. I just want to tell you, I appreciate it. It was good work.
Thank you.
Any other commissioner questions? Yes, Commissioner Walker.
Well, why wasn't there a fact-finding conference? Is there usually one?
The fact-finding conferences and the IRCs are kind of up to the discretion of the investigator. So in this case, I had sent out a request for information from the respondents, and based on the answers that I got back, really, it didn't seem like I needed to have a conference in this case. It seemed pretty clear to me from the facts that both parties had submitted that discrimination had occurred, and there wasn't really a need, from my perspective, to go into any more depth. Now, looking back, could it have been more informative to get more into the administrative process? Yes, but it's a narrow question that we're trying to answer, and you have to, when you have as many cases as we do as investigators, you have to not go down rabbit holes if you can avoid it. So I thought I had enough evidence, so that was the decision I made.
Commissioner David.
Colin, the student support team that's making the rejection decision in August after all these other acceptances, is it correct to say that they are rejecting a licensed mental health professional signing off on saying he would be okay in this environment? His counselor or the DBT program or whichever it was?
I think, I mean, it certainly appeared that way to me, but that's my opinion, obviously. It seemed that they had, respondent is right that the recommendation for it's termed a level 1 safety plan. I understand that that's not exactly, that's not a definitive term, but the idea that, if a complainant didn't show up to class within 5 minutes, the teacher should figure out where he is or why he's not there. I think respondent is saying that they couldn't accommodate that. It seemed to me that the therapist was saying that was enough. Yeah, I don't know. I'm sorry, that's not a very good answer to your question, but
well, his therapist is saying that it's safe for him to be there, correct?
I think so. Yes, I think this therapist was. I mean, he completed the program. The therapist was saying they thought it was safe for him to be there. Maybe with these extra conditions. I don't think that the therapist was ever saying that you need to keep complainant away from rubbing alcohol at all times, or you need to track his sleep or keep him separate from other students. I think this was just information about, things that he had done previously. But it seems to me from the record that the level 1 safety plan or whatever was a suggestion, not necessarily a mandate or accommodation request.
Okay.
Commissioner O'Brien.
Thank you. It's been a while since I've been involved in the college application process. But do you know, Colin, I believe, from what I know, the school looks at academics, they look at extracurricular activities. Do they talk about their mental health? Have you been treated? Is that part of it? Or I guess that's leave it at that. Do you know?
If it's in the record.
Right, if it's in the record.
Part of the admission, that's not on the record. I solely focused on, this case. We didn't get into the greater admissions process for, academics and all the other stuff.
I guess, let me just.
So I could say you could presume that the complainant met those standards because he was offered enrollment. He did get the email saying, congratulations, you've been enrolled here.
Right.
So presumably none of those other reasons were the reasons why he was rejected.
Well,
and the respondent never made that argument.
I guess let me try to make it more clear, but again, you may not know, it may not be in the record. The question is, any student that applies, do they look at the mental health record? So that, or was this just offered? The information just offered to the school?
I can't speak for the other students, that's definitely not in the record, but I can say that I think the complainants reached out to Hebron Academy and were upfront about, you know, the fact that complainant had this mental disability and would, you know, there was a dialogue from the very beginning about complainant's position. So yeah, I don't know if that answers your question, but as far as the other students, as it being a normal part of the process, I'm not unaware of that.
Thank you.
Any other commissioner questions for Investigator Hurd? Seeing none, thank you, Colin. We've heard from the parties and the investigator. At this time, we're looking for a motion. There's one proposed finding. Commissioner Davis.
I'll move that we find that there are reasonable grounds to believe that respondent discriminated against the complainant on the basis of his disability.
That's second.
Any discussion? It's been moved and seconded.
Speaking in favor of that, I really don't think that they found out any new information at all. I think that those are pretextual picking at some new version of what was clearly disclosed to them from the beginning by the consultant, and they engaged in this process and they accepted him, and then somebody changed their mind based on his disability. And I find that discriminatory.
So again, I think I disagree with the commissioner that I'm reading from Attorney Walker's submission that they did find new information in July based on what the complainant's therapist said, and that it would need an additional level of support that they did not otherwise have. And I go back to Investigator Hurd's comment when I asked this question, that maybe there were extra conditions. And the one that kind of got my attention was based on the therapist's recommendation that you would need to locate the student within 5 minutes if you were late for class or for other scheduled events. That seems to be a burden that they may have just learned about in July. And I would have liked to know more about any other of those burdens that came out in July. So I think there was new information that triggered it from the July meeting with them that bothered them. And the one that got my attention, as I said, was this 5-minute requirement.
Any other discussion? Seeing none. Motion is to find reasonable grounds. If you are in agreement, you will vote yes. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
No.
Commissioner Douglas.
Yes.
All right. Findings are reasonable grounds. We appreciate everyone's participation. The commission will send a letter to the parties and council confirming the results of the hearing. Do we have a 5-minute break?
Can we have a 5-minute break?
Thank you.
We will take a 5-minute break.
You're on.
We're unmuted? All right, well then we are ready to proceed with the case of E22-0052. That's Tatiana Morrow versus Cosmo LLC. This is a reasonable grounds case, and as a result, we'll hear from the respondent, Cosmo LLC.
Great, and I believe we are looking for Ms. Amara L.
Hello, I'm Larry Cushing. I'm also one of the ones that responded back. Amara is on audio. So Amara, did you want to introduce yourself and I think she's here.
Ms. L, are you if you're the 415 number, you can unmute yourself by pushing *6.
There she is.
Can you hear me now?
Yes. So.
Hello?
Yep, we can hear you.
Okay. My name is Amara, and I provide this information on behalf of respondent 49% owner, manager of the business, and the personal representative of the estate, Mr. R. Dean, who owned the other 51% until his death on June 4th, 2021.
So I can help as well. Amar and I have talked. I was business partners with Mark Dean and several other ventures, not necessarily in Cosmo, but since his passing.
Sorry, Mr. Cushing, can you pause for just one moment? I'm going to pause your time. Newbert, do you know what Mr. Cushing's role is? Has he been involved in the investigation?
So sorry, can you hear me now?
Yep.
Okay, so Mr. Cushing provided the RA for the account or for the case and then participated in that fashion. And then Ms. L provided additional information and the letter of disagreement.
Okay, sorry, Mr. Cushing, I just hadn't seen your name because it wasn't on the letter of disagreement, but go ahead.
Okay, so again, my name is Larry Cushing, business partners with Mark Dean and several other entities in the Portland area. And I was the one who received this complaint on February 21st, 2021, and worked with Amara to establish the responses back. Just to give a little bit of a recap of what was transpiring during that time, I think is very important in this case. If we look back to March through June of 2021, we were still dealing with a lot of activity with the pandemic that did impact a lot of our businesses. It put several of our businesses out of business. We bankrupted 2 of them. This one in particular, as well as one of our other restaurants, was able to be opened in a limited fashion due to the state's mandates. On April 28th, which was just a week before Ms. Morrow's layoff, the state of Maine had just created their stage for reopening. Our facilities were reeling from open, close, small percentage of people allowed. And I can say that the challenge that we had was obviously, just as the investigator reported, that most of the information in here was based on the complainant's comments because Mark Dean is no longer here to speak for himself. So if we look back towards the information stuff that we did have available, specifically the payroll information and the dates and times, when we look at May 6th, and Amara can provide more detail, but I believe it was May 9th that Mark entered hospice, in which he then passed away on June 4th. So during the time of January to June, the last 6 months of his life, he was in and out of the hospital and fighting for his life. Obviously, after the beginning of May, it was noted that it was end of life care at that point. the facilities that we have and had, after his passing on June 4th, Amara was put in as the PR and responsible for figuring out what we're going to do with these. I know that in the payroll, I see several of the individuals that the investigator had reported that we had hired, but I don't see any payroll information for them until 6/21. And I do know that for a period of time, we struggled with figuring out what we're going to do with the facilities. As Mark was passing away in the month of May, after his death, funeral, all the work with the estate and the attorneys. So I just wanted to put in context when in a lot of this report, again, it's very difficult to look back to find information due to the time frame that we were under and obviously Mark's condition. Now, I do believe that the information in the report did state that we're a highly diverse workforce. Amara and her family are of Asian descent. We have well over half of our staff is of minority status. And that's consistent through all the places that we operate. So again, I don't know if perhaps the challenges and details around this situation was compounded by the fact that, again, Mark was in a state of passing away. Amara was both trying to figure out what to do with facilities while also grieving the loss of a significant other. And again, I'll just say, working with Mark over 10 years, we have had many different facilities. And I just found that one item that sort of bothered me was, there was a comment that was in the statement provided by the investigator. But when it was put in the report, it was significantly different in its tone. And it referred to the music that was played. And in particular, the item to say, we don't play rap music here. Well, that is correct. At that facility, we don't play rap, we don't play classical, we don't play country. And at our other facilities, we would have a different type of music. At our nightclub, we did have rap. We did have a completely different genre. So it was particular that in the interview that was provided by the investigator on 2/16, that it stated, we don't play rap music. But yet in the report, it says, we don't play music for your kind of people. So I find that that is very disturbing to see the difference in the tone of the message and in the information that was provided to us. I, again, will just add that, we create different facilities for different types of people. We had a nightclub that was for the younger kids. We have another facility that's you call it Greasy Spoon. It's one of the dive bars in Portland. Plays a lot more country and rock and old school. And then we have facilities that the Bar and Bites that was designed to play music for a different crowd, a more upscale crowd. So we didn't play rap music. We didn't play other types of music that we often had to instruct our staff because they often thought that the music there was for them. So again, as a normal process of understanding the flow of events, as I stated, we had a difficult time due to the activity going on and the time of the activity. So, Amara, I don't know if there's anything that you would like to add.
Yeah, it's you said it all in there, and I just want to address a little bit about the time that I have called Mrs. Morrow. My job description, I have managed the kitchen staff, which call in the back of the house, and Mark manage in front of the house, because I don't go to the front of the house very often because I'm allergic to alcohol. So therefore, I seldom to be there. And whatever he's handled the situation by the hiring or firing or whatever is his job. But there was a time when he's in the hospital and he just called me for a few important financials and operational issue. That one of the thing is Miss Morrow case. So I had made a call to her according to the information that he was giving me, that just because she took full-time job somewhere, she only can work on Friday night and Saturday night. And she sometimes late, she sometimes doesn't show up. So, but I only got it from him. So I did make a call to her. That's about it in that situation. And like I said, you have any questions, you can just ask me. I will answer the best of my knowledge that I know about this matter. And it beside the, not to add on, but Mark employ a lot of different ethnic group of people. All the kitchen staff that I have is combination of Asians and Latino.
Ms.
And,
L.
and
Mr. Cushing, that is for 10 minutes.
okay, then I'm just gonna cut off right now, and I'm gonna leave it up to you. Ask me a question that you need to. Thank you.
Commissioner, questions for Mr. Cushing or Ms. L? Commissioner David.
Mr. Cushing, you referred to the fact that you do have the employment records to consult, even though you don't have the owner. She's discharged on May 6th, according to the investigator, and a week later you hire another person for that same position. Is that confirmed by the employment records?
No, according to the payroll reports, we have.
Mr. Cushing, hang on a moment.
You're on.
You're
Can't hear you, Newport.
No, hang on.
Okay, there we go. Those records are not, the payroll records were not provided to me during the investigation. They are not in the record. And I just wanted to let the parties, you guys know.
Great. Then Mr. Cushing, you can't reference documents that the investigator does not have.
Okay, I don't believe payroll records were ever requested. Employment records were.
Well, if you didn't provide them to the investigator during the investigation, then we can't hear about them now.
Okay. So I'm not sure how her reference of a comment that somebody was hired a week later is relevant then, since I could say nobody was hired until the mid-June.
It was because I referred that person to.
Ms. Morrow,
Wait.
Ms. Morrow, well, you'll have your time.
I'm all set. I'll ask others.
Okay. Any other commissioner questions for Mr. Cushing or Ms. L?
I guess you do have this need to rely heavily on these records, and so that's why I guess we're talking about them so much. I think I understand you to say, Mr. Cushing, that the pandemic order that came down from the governor's office on April 28th expanded, didn't it expand the opportunity for folks to go to bars and restaurants? It didn't limit it more further or more. It was actually, we were emerging from the pandemic in late April of 2021. Is that correct?
Well, I believe in April 28th, the May 1st timeframe was opening up additional facilities. Bars were still were not allowed to be open. Restaurants were still allowed to be open with limited capacity, but it also depended on the outbreak status in the community.
Fair enough, but then maybe it didn't even apply. You made reference to it, not me. I mean, you're the one that brought it up, but you made reference to an April 28th pandemic order as if that were significant, but it looks like the complainant's hourly regular hours on April 19th, prior to that order, were 43 hours. And then after that order went down steadily from 29 to 14. And then, of course, she was laid off. It looks like only after the order, which expanded things, did her hours go down. So isn't that the opposite of the argument you're trying
But
to
the
make?
order didn't expand. On April 28th was the reopening plan from the state.
Okay.
What it outlined is over the course of the next 3 months, which counties, which businesses, and what the requirements and items around those would begin to be opening. So, I mean, I have it right here, May 1st, it's drive-in movies and state parks and auto dealerships. In June, it's the ability to open up additional restaurant activity, again, based on the community spread in the county. So it was just setting up the plan over the next 3 months where the state was planning on really opening up the different business types. So there was no change at that point to what we were capable of doing in the Portland area.
Okay, so there's no change then. So there was no change, and yet her hours keep going down. How do we explain that?
I'm not sure where the first set of hours, I mean, I can tell that the revenue from our companies continued to dip and continued to be impacted by the impacts of COVID. But I don't know, again, the 43 hours, I would have to have her actual time cards to see, was that 1 week? Was that the first 2 weeks of work?
It was provided in the respondent's response.
Yeah.
Okay, thank you.
Any other commissioner questions for Ms. Cushing or Ms. L? All right, seeing none, you have used your time, so move on to Ms. Morrill. Ms. Morrill, if you could unmute yourself, you have 10 minutes.
Great, thank you. Sorry for the interruption earlier. So yeah, I mean, my original complaint is still my original complaint. There isn't much for me to argue within my complaint. What I placed there is precisely what happened. I started work there on, some early day of March. It's listed on there. And in that time, COVID was full form. We were all wearing masks, including inside. I worked one shift at not the Barn Bites. I was hired under Rosie's, which is another Cosmo LLC company, in which I worked one shift, had satisfactory levels. I was told after that one shift that my appearance did not work for that location and that I was going to be moved to the Barn Bites because they really needed help. They didn't have enough staff. They had one girl working over there. I went over with Mark, the owner, who was the one to give me those comments about the music that was played and how I was, around town. I knew what his bars were like. Essentially, had a bunch of words that I didn't include in the complaint, but of course, the ones that I did place were things that were said straight to me and did have a negative connotation to them. So I was extremely uncomfortable with that, just to be said from there. Either way, I started right away. I let him know the same thing I had let the person who originally hired me at Rosie's know, that I was starting a new job. I had been hired almost that same day that I was hired for this position at another place where I'd be working full time. And I said which my start date would begin on. And I did give all of these employment dates for both positions, all of the jobs that I was working at the time, which I believe I was actually hired at 3 different places, in which I provided those, let him know that I would pretty much only be available on weekends and nights after I get out of work, in which varied because different days I had different hours at my job, in which I communicated with the person who was not necessarily my direct report. She was kind of my colleague. Her and I got along very well during my time there. didn't have any issues. So essentially my firing was a huge surprise. It was a holiday weekend. We had talked about hiring more help. We had created a new spring menu. We were doing business as usual. We were doing $12,000 plus of sales with absolutely no one following COVID restrictions, in which case I had to go and get a COVID jab because it was seriously not safe. We weren't provided mats. We weren't provided with a bunch of things that probably should have been provided. And also we were told when we were getting out of control, which there was no way to keep it in control with 2 people on the floor working 12 plus hour shifts with no breaks, because you can't serve a bar like that by yourself. And we were told, place the Black people in the back of the bar. That was a mandate that was given to us, directly from Mark's reports. And that was told to not just the girl I was necessarily a direct report, but also to other members of Mark's other locations. So Rosie's Slice Bar or whatever. One thing I'd like to mention is I don't know what Mark and Amara's relationship necessarily was, but what I can absolutely tell you is that the kitchen staffs and all the other people that she's referring to, from my knowledge, working there, with the one busboy that we had on, a few hours a night, he was related to her. The people in the kitchen were somehow related to him, which that would make me assume that they're all related. So maybe you have a diverse staff, maybe not. They seem to be related to you regardless. I know other people who have worked within Mark's establishments who have been people of color have not necessarily had wonderful experiences either. I'm not going to call on those because they're not part of this report, but of course, I also went back to visit the same girl I had been working with after I had been fired. I tried to ask Mara, same thing in my complaint. Like I said, I keep it pretty much to my complaint. I don't have any different story, but I did go back to the location on June 10th or 11th after Mark would have been passed, and I was told I was banned. I was told to leave. I was extremely humiliated. It was really disturbing. I was told that I shouldn't bother Amara in this time of her husband's death, blah, blah, blah. That was just what was told to me. I don't know the relationship, but I was effectively told to leave.
I believe at least some of this is not in the record.
Okay. That was in my original complaint. So I just want to make sure. I'm only trying to preface on what I've placed with the investigator. But other than that, I did place in my dates of employment were placed by Cosmo. I put in the documents of what days they said I worked. They actually said that I started working almost 3 or 4 weeks after I started working. I never received a paycheck in hand that wasn't voided. I never had direct deposit. It took a month and a half or so to even receive a W-4 form, which I tried to ask her about when it came tax season. I also had like the most insane taxes I've ever had that year due to that situation and how that was placed with my taxes, in which I also set in with my complaint how many times I reached out to Amara in concern with those documents. Trying to align those. And I also saw that on the documents that she had uploaded onto some system I never used, that I was supposed to be getting a paid hourly rate of, $9 or $18 an hour. I never received that. And we were in a state of emergency. So I was getting paid in cash every single night and I was sent home. So I essentially don't necessarily agree with a lot of the statements that have been made or tried to be made. I've had to refute quite a few of them between the statements given that I've given, the responses. I've had to, they say, oh, well, we don't have her starting till March 26th. Well, here's a picture of me behind the bar on March 17th on St. Patty's Day. And there's just a lot of things. I never met Amara except for one time during a drawer swap. So a lot of the things that she provided, I can't even say are true. And I know that she wasn't really the, manager. She did back of house, but yet she's 49% owner. And she would have had to have had knowledge of some of of these things that were going on, even if Mark was, he said that this was like her bar or whatever, but essentially, she owned 49% of the company. So saying there wasn't much detail and that it's not working out when I had no prior conversations about my employment was kind of a double standard. And it was hard because she was unable to provide his statement, even though she was the only one who had contact with him during an extremely sudden layoff prior to his death. But either way, I could not help but feel that it was extremely targeted. I had already recommended someone else who I knew to come and work with us, in which Amara brought on her ex-daughter-in-law to help us essentially. And her daughter-in-law also knew this person that I was referring to hire. And she was fully behind it. We were training these people on the bar very hard because it was extremely busy. There wasn't even enough time. We scared somebody away in just a day with how busy it was and how little help that we had. And I did my very best to make it a inclusive environment and invite people there. I did not want to place Black people in the back, and the girl I worked with also did not agree with that statement. We wanted to play music for people who were entering our bar, and of course there were a lot of restrictions on that, and there were talks about different concerts that were going to be coming in, and those were of a completely various sort of people, which included hip hop DJs, other VIP areas, which you would then assume it was just kind of like any other bar in the Old Port. But I think I'm most humiliated by the fact that I was never returned a call. I was never answered. I was the only one to be fired at this time. I didn't have any prior information about any of these, issues about my timekeeping. I never missed a shift. So I don't know what that was about. I went every single day, every single time she needed help that I was available, I was there. And it wasn't that Miss L was asking me for my hours. This was the direct report that I was working with. And who I don't even know if she was actually even a manager of any kind. But like I said, she was just a colleague, but I did feel the most humiliated by when I went back to visit and I was effectively kicked out immediately and told I was banned. And I had no idea why.
Ms. Morrell, that is your 10 minutes.
Thanks.
Commissioner question, you get Commissioner Douglas.
Ms. Morrell, good morning. Yeah, I want to direct your attention to the respondents' comments about the type of music that was played, right? They take great issue with this comment that, we don't play music for your type of people or whatever it was, and they point out that they play country, but they don't play country and Western, they don't play classical and all this kind of thing, right? But I'm looking at the report, and it was that was sort of part of a bigger comment, a broader comment, where it says, we don't serve Hennessy and we don't play music for your kind of people.
Mm-hmm.
For my colleagues that have never worked in a bar or restaurant, I would like you to explain to us why that comment about Hennessy is problematic.
Yeah, absolutely. I mean, I've been in bartending for an extremely long time. I'm also a person of color. It's an extremely popular drink in the African, Black, and Hispanic communities, as well as some of the Asian communities as well, in which that was a huge signal to me that this was not a place that, these people were invited. And there were multiple people on the ban list that he listed at the same time that fit all of those categories. So that was why that comment was extremely disturbing.
Just to be crystal clear, right? The perception in the industry is that Hennessy is a drink for Black people. Is that correct? Okay.
What is it, a whiskey or?
It's like a cognac whiskey kind of a thing, yeah.
I don't.
And the comment about seating Black people in the back of the bar, I just want to be very clear about this. How did you hear that comment? From whom and when?
That was given from the direct report after a manager meeting where I came in before shift to discuss what was at the meeting so that we could reinterpret those into the day-to-day, since it was just the two of us. She said, there are some really bad comments that were made there, made me uncomfortable. This is what was said. I don't believe that we should do that because that was a huge part of our clientele. And it was to keep them away from the windows because he didn't want people to be seeing them inside from the window outside. That's why he wanted them in the back.
And did that happen to any extent at all? Black people being seen in the back?
When I was working, absolutely not. I can't say what happened when I was not there since there was only 2 of us, but I know that she did not feel strongly about that. And I don't believe that we personally enforced that. But there was security, of course, and they were not part of our, they were the ones who were letting people in essentially. So I don't know if that was ever something that they enforced.
Fair enough. But what I'm understanding you to say is that was the direction for management to see people of color in the back. Correct? All right, thank you.
Commissioner David.
Morning, Ms. Morrill. Do you know how long after you were fired, someone else was hired for the same position?
I believe it was only like a week or 2 after I had left. I went back in on that June 10th date. And I know that, Amara's daughter-in-law was then fully placed into the staff. They hired the girl that I had recommended within somewhere in that time period. I don't know if, so I was May 6th, so had to have been within weeks.
And am I understanding you to say that from your perspective, when you were fired, you were quite busy? The business was quite busy?
It was extremely busy. We didn't have a moment to take a break.
Thank you.
Any other questions for Ms. Morrill? Commissioner O'Brien.
Thank you. Hello. I'm concerned or questioning about the workforce being a very diverse. And you mentioned that the back of the how do you call it? Back of the house. Back of the house was mostly relatives. But can you speak to the fact? I mean, you're asserting, I think that you are asserting that the owner was racist. So could you explain why you think you in particular were discriminated?
Yeah, at the time that I was working there, I obviously worked at Rosie's. I frequented into, Mark's Place, and I frequented into the other 2 bars that he had owned. And I don't remember if they were all open at this time, but of course, within months, it was just COVID. And I cannot recall and asking other employees throughout those locations if they worked with any other people of color, and the answer was no. Even with my experience working there, I was probably, and I think I'm extremely sure that I was the only Black person who was working for Mark within all of his locations in the Old Port at that time.
Okay, I think that's enough. Thank you.
Any other commissioner questions for Ms. Morrill? Seeing none, thank you, Ms. Morrill. We will hear next from Investigator Leyva.
Good morning, commissioners. This report was mostly written based off of the information that I had. Respondent did not provide a lot of information. Neither one of the parties that were giving the responses for respondent were present when the conversation was had. I couldn't then kind of figure out or invent what he said. I took the complainant on their word because they were the only other party that was present during those conversations. And that's why I understand that the record looks like it's lacking a lot of information, but I did not have a lot of information to go on. So if you have any questions, I'm happy to answer them. There isn't anything extra to tell you that wasn't in the report.
Thank you, Newber. Any commissioner questions for the investigator? Commissioner O'Brien.
Piggyback on the question I just asked. Did you, in the record, did you have any? Never mind. I'm talking that back. Never mind.
Okay. Commissioner Douglas.
No,
Oh, sorry,
go ahead.
saw your hand, okay. All right, any other commissioner questions for Investigator Leyva? None, thank you, Newber. We've heard from the parties and the investigator. At this time, we're looking for a motion. There's one proposed finding.
Yes, I'll move to adopt the investigator's report and find that there are reasonable grounds to believe that Cosmo LLC discriminated against Tatiana Morel on the basis of her race, color, and or national origin. Conciliation to be attempted in accordance with 5 MRS 4612.
Second.
Jeff, is that you?
Yes.
Okay. All right, it's been moved and seconded. Any discussion?
All I will say is I think this case speaks for itself.
I
Yeah, I don't think there's any discussion necessary.
agree, it's quite clear.
I don't want to suggest discussion isn't necessary, but I do want to address one point that's raised a couple of times here. I appreciate the concession on the part of the investigator, but and maybe at the time of the writing of the report, a great deal of contributions hadn't been made by the respondent, but certainly the respondent's agents provided lengthy response to the investigator's report. And I'll just say, I don't see anything in that lengthy response or in the arguments made here today that change at all the investigator's findings. So I guess I just want to make sure that the respondent hears that this decision isn't being made because we didn't know the other side of the case. I think that the defenses, so-called defenses raised in the responses just aren't good defenses at all. In particular, this discussion about the pandemic being a reason why we had to lay this employee off. That's just, and remember, it's not a hostile environment case. It's a discriminatory act case. And it's the layoff, that's the discrimination. And I think that even in the response and in the arguments made today, it's just not credible to suggest that it was the pandemic that resulted in this person's layoff. So that's, I guess I just want to add to that.
Any other discussion? Seeing none. The motion is to find reasonable grounds. If you're in agreement, you will vote yes. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes, halfway, yes.
Okay. Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
All right, the findings are reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties confirming the results of the hearing. Thank you all for being here today.
Our next case is E22-0134, Ruth Lauren versus Northern Maine Medical Center. This is a reasonable grounds case, and I understand we'll hear from representative of the Northern Maine Medical Center.
Any Langsdorf? You have 10 minutes. Would you like to reserve any of your time?
2 minutes would be fine. Thank you. 1 second. I'm slightly claustrophobic from being behind a mask for the last few hours. So 1 second, set my own timer here. Okay.
All right.
Thank you. On behalf of Northern Maine Medical Center, I'm Steve Langsdorf, and I'm here to talk about why we do think that the investigator got this report wrong in terms of indicating that Northern Maine Medical Center, which is a hospital located in Fort Kent, Maine, discriminated against employee because of her national origin or her race. I think just a little bit of background about the hospital itself would be very important to put all of this into perspective for you. I think everyone probably intuitively knows or has read that it's exceptionally difficult for Northern Maine and some of the more rural parts of our state to attract doctors and other medical professionals. Because of this, there is a very, very high percentage of employees, doctors and others who are working at the hospital that are from other countries. And this was talked about during our fact finding that we have, but there are a number of doctors that are from Russia, other parts of Eastern Europe, Africa, Guatemala, Honduras, Philippines, and so forth. So it's to begin with, having the medical staff and people working in the hospital with their different forms of accents, so to speak, is it's just the way that it is at Northern Maine Medical Center. In addition, as I think everyone understands, this is directly on the Canadian border, and a very high percentage of the people who are both working at the hospital and also are patients at the hospital. English is either their second language, first language, but they also speak French. And so this is a highly international hospital located on the border. So the idea that there would be a problem per se with somebody working at the hospital with any form of accent is frankly not supported by the record and doesn't make any sense in this context. Also, it should be understood that this individual obviously spoke the way that she spoke, when she was hired for her position. And so if this was again something where someone was being discriminated against because of an accent, one would think that the person was applying for the receptionist type of position that she was, that would have been noted, and if someone's going to discriminate, that's when that might have happened, which obviously never happened in this particular case. I think in this case, what we'll hear a little bit about accents, and I think accents is a bit of a misnomer in terms of the process or what was happening in this situation. As I said, accents themselves are not a problem. We heard someone in the previous talk, and she had an accent, but you can understand clearly, what she was saying, and so the problem never is that someone, say things in a way that's different than maybe others. It's difficult for me now to even conceive of a business to think that would be problematic. What we've had here, and what we had very specifically in situation, was simply an extreme difficulty of both understanding what it was that the employee was saying, and for people who were calling in to understand what she was saying, as well as other frustrations and problems that were going on in the job. After all, we're working in a medical situation, and this is someone who certainly could speak English to a certain degree and fairly well, but not to the point where she could handle the type of detailed, very, very specific type of communication where there's really no room for error that you would see in a medical, in a medical facility. This really required in those kind of very effective communication. She was routinely communicating sensitive information, answering the phone, confirming patient appointments, directing people to other parts who have emergencies, to other parts of the hospital, again, people who may be upset themselves and having difficulty speaking. Telling people what records and giving instructions to bring up to appointments, prescription refill bills, and so forth. Directly from her job description talks to boarding calls, needing triage, scheduling test procedures and referrals, verifying patient portal to make sure patient concerns are addressed, notifying providers, dealing with canceling and rescheduling employees, and the ability to inform office, nurse, or provider when a patient calls regarding complications after a procedure or surgery. Obviously, this is the type of a position that requires someone to have really complete and 100% ability, not only to be able to understand and to speak, but for them to be understood themselves. So in this situation, this was a probationary employee who did not work out, at the end and before the probationary period expired. She was relieved of her duties, but was at the time told that she was free to apply for other positions within the hospital, which she did not choose to do. She worked in two different departments, family medicine and then in the internal medicine. And more of the problems developed when she was working in the internal medicine department. So the investigators sort of suggested that there were no efforts to coach and work with her and so forth. And that was not at all true from the record. There are numerous emails and other documents that were set forth in the record that do support the fact that there were discussions of that nature. I mean, to a degree, obviously, you can only go so far in terms of coaching when it comes to somebody's ability to understand and to be able to to speak English, but there were very, very numerous notes, and there are all sorts of names here, which I will not name any of them. And for example, on March 10th, it was sat down with Ruth, and she was told, I highly recommend Ruth to take note the patient's name, enter date of birth on the phone. She would have that note to reference. I asked Ruth to speak slower when talking to patients. March 15th, she was talking about Ruth's struggles with scheduling an employee and that she was having trouble. There was an increase in patients who did not fully understand their conversations. 2 different other employees came to speak to this individual with their concerns. There had not been any signs of her slowing down when speaking. She continued to use rough English and so forth. She got frustrated and would throw her hands up in the air and so forth. So there was a specific comment that was made in the record that indicated, well, we were concerned about accent, meaning understandability. We stated specifically, we were concerned about this individual's ability to speak and understand English. If this all wasn't enough, then when we had the issues and resolutions conference, the individual had to communicate through an interpreter. And so while that's certainly understandable, if something might be a situation where that's appropriate to do so, but to me, that was essentially an admission that the person really couldn't communicate well enough in a situation to feel comfortable to be able to do that. After all, the fact-finding conference was solely talking about what she did, her job, and her position at the hospital. Seemingly, she should be comfortable in that area. I'll reserve the remaining 2 minutes. Thank you.
Commissioner, questions for Attorney Langsdorf? None. All right. Commissioner,
You made the comment, or not sure you even knew that you did. You talked about other situations where there are problems. You use that term, other situations that were causing her not to work out.
Well, there was frustration that was shown. She was because basically she was speaking very loudly. There were just some other sort of tangential types of concerns I think could have been probably worked through. But again, as a probationary employee, they were addressing the primary concerns that they were dealing with.
Yes. Is it a bona fide occupational qualification to speak English to do this job?
Absolutely.
So is this a VFOQ case?
No, I didn't look at that. I mean, well, yes, to the extent that absolutely it was required that she be able to speak English well enough to communicate at the level that was required in all this. I think I was thinking about that there are cases that talk about whether a BFOQ without any form of accent, is a job requirement. And I wouldn't say that at all, because just that's not the issue. But in terms of being able to actually, that was one of the essential functions of the position or a BFOQ to be able to speak English at the level that was necessary to communicate in all these various types of significant medical issues. Obviously the consequences of a mistake in this area can be, threatening to somebody's health or even in their life. And we just didn't believe that she had that, which I thought when the interpreter came in was really a concession of that. Yes, Commissioner.
Would you agree that what you're saying is that we're not talking about speaking English with an accent? When we say speaking English, we're talking about comprehension of sophisticated, somewhat complex concepts and the correct way to describe those and to understand those when patients are describing them and to describe them in the reports she's making of the phone calls and that kind of thing.
Absolutely. And like I said, the fact that if she had spoken with an accent per se is meaningless. The doctors and so forth who are there and they all speak. It's nothing to do with accent. The term accent was used, and I think this is sort of seized on by the investigator. Well, it's the accent, but I think in their context, they understood to mean we have trouble understanding what she's saying.
Comprehension.
And then beyond that, it's very clear in the written record that there were specific concerns about her ability to understand and really speak well enough. She would speak in rough sentences, sometimes not use the proper possessives, where in many, many positions that would have been perfectly adequate level, of English to, be speaking if you're serving on a bar, where we heard that last case, but very different when we're dealing with obviously a medical situation.
So just to follow up on what you just said, so the report says at the end, excuse me, finally, service coordinator told complainant that she was fired because of her accent and the way she spoke English. Do you think that we should take a more nuanced view of that?
I think you'll also read the section in the report that was quoted directly from the record, where it talks about it's not just accent, it is in fact this ability. And again, I think when we say accent, it isn't because we don't like how you sound, it's just we don't understand, how you're speaking. People, dealing now with a lot of people who are French-speaking people and just couldn't understand, what she was saying, and she would speak very quickly, which she amply demonstrated in the issues and resolutions conference. She would get going really fast, which is even more difficult to understand. So I do see how using that word accent kind of is a bit of a red flag, but I think when you look at what's actually happening in the record here, that's really not reflective of the reasons why that the employer made the decisions that they did.
And so when you say, I'm sorry.
No.
When you say that she wasn't a good fit, that references the communications issues you've been discussing.
Absolutely.
Is that correct?
Absolutely.
Thank you.
And in fact, the record has, if I remember correctly, I don't see it in front of me, but it has specific examples, right, of patients actually complaining that they could not understand,
There were
couldn't
numerous.
communicate with this individual.
I'm sorry to interrupt. Yes, there were numerous complaints that were received, people calling and saying, I just thought I got a call from the telemarketer. I didn't understand what was happening. Can you please explain? Now, this is a probation employee, so you're not going out and getting statements from the people who are complaining and so forth, but they were responding to not only what they were observing themselves in the workplace, but also concerns that were being brought to their attention by their patients and themselves. So.
It's clear that she was offered the opportunity to apply for other positions.
Absolutely.
The complaints that you just referenced, I believe the report says that there was no sort of supporting evidence other than the statement that there were complaints. Are those complaints documented in any way?
Yes, they're in some of the emails and references, and several of the emails, if I have it all, it talks about the fact that you're getting complaints about this thing I just said about the telemarketer is in there. There absolutely is reference in those to the fact that complaints were being received.
Thank you.
Footnote 4 in the investigative report indicates he did not argue and have not proven that speaking unaccented English is a bona fide occupational qualification, but you kind of are arguing that, aren't you?
No, I'm not arguing that at all. I'm saying that it's perfectly fine to have an accent as long as you can speak English well and you can be fully understood. It has nothing to do with unaccented.
Correction. I see the distinction. Sorry. Speaking English though is a BF.
Absolutely.
Any other commissioner questions for Attorney Langsdorf? Seeing none, thank you. You'll have.
Thank you.
Back. Ms. Moran, you have 10 minutes. You are muted right now if you're speaking with me. Mr. Bois?
Yes, hi. My apologies. My name is Alan Bois. I'm the Chief Operating Officer for Northern Maine Medical Center. I believe the M. Moran that you see on the screen is Matt Moran, our new Director of Human Resources at Northern Maine Medical Center.
Oh.
All right.
Okay.
Very helpful.
Somewhat close.
Yep. Yep. All right. Ms. Moran, I don't see anybody whose name I don't recognize from other cases, and I don't, Chelsea, we don't have anybody in the waiting room, right? Okay. Well then, Attorney Langsdorf, you have 2 more minutes if there's anything else you'd like to add. Otherwise, we'll go to the investigator.
Just 1 second. Just briefly, I just got looking up the notes of regarding the employees and just in response to one of the questions that was just raised. And blank received a call from blank. He stated he had just received a call from a person who sounded like a telemarketer, was not able to understand the receptionist, as well as where she was calling from. Girls are also receiving reconfirmation calls throughout the day since they did not fully understand the receptionist who had called them. So I just wanted to point out that these were complaints that were noted.
All right, well, we have heard from respondent. Complainant does not appear to be on the call. I'm just gonna go check the waiting room and make sure that we don't have anybody in there. I don't think there is. Complainant is not here, so we will move on to investigator Leva. Yes, right.
Hi.
A little bit, but Nooper, whenever you're ready.
Okay, great. I should not be on mute, and so everybody should be able to hear me. Hello, once again, commissioners. This report, what can I say about it? The emails that Mr. Langsdorf is referring to, yes, they were included in the record. And read as a whole, in the information that had been provided to me, it felt as if they were just comments that were being passed back and forth between employees. It wasn't like it was an actually documented concern. There weren't very many like coaching documents or anything to show that the employer had tried at all to help Ms. Morin achieve the level that she may have needed for the position. And I understand that speaking, maybe even a little bit accented up north, is a much more difficult process. But based on what I had received and the comments made, even explicitly by the parties, that her accent was at least one reason why she was fired. It may not have been the overriding reason. There may have been other reasons, but that was at least a contributing factor to why she was dismissed. That's really all I have to say.
Thanks, Nooper. Any commissioner questions for the investigator? Commissioner David.
Nooper, would you agree that the particular setting here is one in which the comprehension of English and it is particularly important and crucial and can be complex in the medical setting, both for medical terms, drug terms, description of symptoms, all of those things?
Yes, I absolutely agree. I think that that is a very important factor. But while I did understand that maybe they were having difficulty understanding her, it really did just end up being that the accent was a contributing factor of why she was dismissed.
Why does she need an interpreter for the issues and resolution conference?
Because she was most comfortable in Spanish. I mean, that's a speculation on my part. I can't really tell you why she requested one, but our parties have the ability to request interpreters, and she was provided one upon request.
Any other commissioner questions for the investigator? Being none, thank you, Nooper. So we've heard from the respondent, we've heard from the investigator. We'll give one more call for Ms. Morin. Don't think we have her here. All right, so there is one proposed finding. At this time, we'd be looking for a motion. Commissioner Ashby.
I'll move that we, with all due respect, reject the findings of the investigator in this case and find instead that there are no reasonable grounds to believe that respondent discriminated against complainant on the basis of her race and/or national origin, and this case should be dismissed.
Second.
Been moved and seconded. Any discussion? Want to jump the gun? All right, seeing none, it's been moved and seconded. The motion is to find reasonable grounds. Sorry, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
No.
Right, so the findings are no reasonable grounds. We appreciate your participation, and the commission will send a letter to the parties and council confirming the results of the hearing.
Thank you very much. Thank you. Our last, no, I'm sorry, not our last.
Try.
Our next case is H230049A through D. This is John McLeod versus Madison Avenue Associates, Sandra Barre, Speedway Inc., and Windward Apartments. This is a no reasonable grounds case, and as a result, we'll hear from the complainant or his representative.
Good morning, commissioners. I just want to check to make sure my volume is okay and that everyone can hear me today. I know that last month there were some concerns. Okay, good. My name is Alice Neal. I am here on behalf of John McLeod, and I would ask that the commissioners reject the recommended findings by investigator Hurd to find that there are reasonable grounds that discrimination occurred, creating a hostile housing environment based on John's sexual orientation and or sex, and that he was also that there are reasonable grounds that MHRA retaliation did occur in this case. And if the commission decides that based on the presentations today, that instead, as I offered in the alternative, that the investigation should be reopened and more investigation should be done, then I would request that happen as a consideration. Mr. McLeod is a long-term resident of at the premises where he's resided for very many years. The respondents have known that he is a gay man from very early on in his tenancy. And there are a few things that I'd like to just clarify, or just to not clarify, but just to talk about related to his time and his tenancy and the claims in this case. I did provide a fairly detailed submission of disagreement, so I'm not going to try to reiterate that whole thing. And Acting Executive Director Thompson Crossman, I forgot to ask, may I please have a 3-minute warning? Thank you. So in this case, related to the hostile housing environment claim, one of the things that I think is very important to note is that it appears that this was looked at as a vacuum of an instance where there was one report that was taken into consideration related to a timeline of years worth of discrimination that John experienced based on his sex and his sexual orientation in being a gay man. John reported issues related to sexual orientation discrimination multiple times over the years. He was not met with any kind of, as far as he knew, investigation or response or action related to that. In fact, at the Issues and Resolutions Conference, we had multiple managers who were there, one who I called Property Manager 1 in my submission of disagreement, who acknowledged that he knew that my client was called, among many other things, that there were words used to describe him, such as a pussy, a fucking pussy, a bitch, a fucking bitch, a faggot, cunt, fucking cunt, asshole, or a fucking asshole. And that also my client reported to management that he was told by a tenant to go suck and to fuck and to fucking die, to go suck a bag of dicks or to fucking die. And this was something that Property Manager 1 acknowledged that he had heard, that John was told that he was a faggot, that Property Manager 1 acknowledged that he had heard the phrase that my client had been told to go suck a bag of dicks or something of that nature, and that respondents' answer indicated that whenever they receive any kind of complaints related to protected class status discrimination, that they do an investigation either internally or work with their attorney. And it's not clear from the record that any of these instances related to the aggregate of the complaints that my client alleged over a period of time of years was ever actually looked at or considered prior to what the report says. It drops a footnote that says that anything prior to February of 2020 will not be looked at because it was considered to be resolved. That to me is akin to saying, oh, employer, you've decided that these instances don't rise to the level of discrimination, so you're going to say they're resolved, and because you say they're resolved, we're just not going to investigate or look at that. These are not individual instances that happened. They happened multiple times over very many years. In fact, it took until my client had a recording of the neighbor saying that he was a faggot through the wall for them to do anything. And then during that same exchange, as you'll see from what I provided as part of my submission of disagreement, that my client was told that the audio quality wasn't good enough. And so perhaps he would have a better audio sometime in the future and they would do something about it. I would say that looking at just the June 20th letter or thereabouts as the one instance of hostile environment report or discrimination is not looking at what really happened in this case. Hostile environment claims aren't meant to be looked at on a case-by-case or an incident-by-incident basis. They're intended to be looked at as an aggregate, as a whole. And in this instance, that is what my client reported. And in the same vein, it is also that my client shouldn't be looked at as saying, oh, well, the landlord decided they resolved everything, when in fact the record shows the landlord really didn't do anything. And so the landlord didn't take prompt or immediate action in response to these years of complaints related to sexual orientation. And I would question if the property manager said that property manager one said he didn't think it rose to the level of something that needed to be investigated. I wonder if that would have been the same response to someone who is a perceived female-bodied individual. I think that if a female-bodied individual or perceived female-bodied individual who is a tenant reported, I have this male tenant who is calling me these sex-based names and telling me to go suck a bag of dicks, that perhaps that might have been investigated, but that my client's sexual orientation and or his sex led to sex stereotyping that meant that his complaints were not taken seriously. Because in fact, as the record has shown, that within less than 6 months of neighbor moving to a different part of the premises where the client lived as part of this apartment complex, and an elderly female neighbor residing nearby, that this tenant was actually evicted because of his disturbances that were caused to this other neighbor. And so it's interesting that even though my client complained for years about harassment, retaliation, sex-based statements, being told to go suck a bag of dicks or die, that instead it took less than 6 months after he moved for an elderly woman across the complex to actually evict him or take steps to do it. In fact, my client reported an instance of harassment and discrimination by this tenant, this neighbor, in June 16th. Of the same year that, well, this cycle of year that we're talking about. And in that is where there's other conversation that gives rise to things that are related to the complaint that have been outlined, related to his accusation that he had a stun gun, which then respondents say is the reason why he was given this notice of intent to terminate. In reality, respondents never replied to that instance that was reported about the harassment that was done by neighbor in mid-June. And the report reflects that the report doesn't touch on that particular instance of harassment as part of the investigation. And I believe that my client has given enough information to the commission to show that there is liability, there is a hostile housing environment, it is sex-based and sexual orientation-based, that a subjective and the objective standards have both been met, and that there's liability on behalf of the respondents in this case because they did not take prompt and immediate action. And
That's
so
7 minutes, Alice.
Okay, I will leave that for now and respond after Attorney Russell. Thank you.
Questions for Attorney Neal? Seeing none, Attorney Russell, you have 10 minutes.
Thank you. If I could reserve 2 minutes, please.
Sure.
Thank you. Good morning, commissioners. As is often the case, respondents have a very different story of what they consider to have happened in this tenancy. I think I do want to spend a little time going over the history, because there's this assertion that my clients have had notice of the discrimination for the entirety of this tenancy back into 2015, and that they failed to act. But my clients have a very different story about when that happened. So to give a little history, the complainant moved to this property in February of 2015, and the tenant that we've called neighbor moved to his unit in November of 2015. By all reports at that time, they both got along for the first 2 years that they were neighbors. Then in 2018, both the complainant and a tenant in a neighboring unit began complaining about neighbors' loud music, screaming, and yelling. And the record shows that there were not complaints of a discriminatory nature, but rather that neighbor was having fights with his girlfriend or with somebody else in the unit, and there was reports of that. This all culminated with an altercation between the neighbor and his grandmother outside of his apartment in February of 2018, which resulted in him receiving a lease violation. 2 days later, complainant told respondent that he wanted to call adult protective on neighbor. He did not feel that neighbor belonged around decent people. He felt unsafe and had purchased a stun gun and mace for personal protection. The statement about the stun gun is important because that comes up later in this case. Neighbor, on the other hand, reported he felt harassed by others at the property at that time who were constantly watching him, taking videos of him, looking in his windows and pounding on his walls. And he was also part of a protected class. It was relatively quiet from early 2018 until late 2021. In late 2021, the police were called on several evenings as a result of complaints both by neighbor and complainant, but no charges were filed that the management was aware of. It was unclear who was doing what. There were no complaints from any other households surrounding either of them, and neighbor and complainant both had very different accounts of what was occurring. One thing that complainant and respondent report very differently is when complainant first reported discriminatory behavior. Respondent states that a review of their memories, as well as a review of the files and the emails, show that it was not until December 5th of 2021 that complainant first made a complaint to property management regarding the language that he now bases his complaints upon. Thus, while complainant's counsel states that there were ongoing complaints for the entirety of the tenancy, respondent argues that there were noise complaints, but nothing that could be considered discriminatory until December of 2021. And included in our response, we provided an 1.5 inch thick stack of emails and correspondence between respondent and complainant. And those emails back respondent's statements that these complaints did not come to them until December of 2021. There was an audio of an issue that occurred on December 5th that complainant did provide to respondent. However, it was difficult to understand, and respondent stated that they were not convinced they heard what complainant claimed was on the recording. Respondent investigated the complaint, talked with both parties, and learned from the neighbor that complainant pounded on the walls and screamed out the window at the neighbor, as well as that the complainant had been yelled at by neighbor. Based on the information respondents had before them, they engaged the assistance of their attorney. After speaking with both parties, reviewing audio recordings, and discussing the matter, it was decided both tenants likely violated their lease and were making harassing gestures towards each other. As a result, a letter was sent to each tenant on December 22nd. They were different letters. The letter to neighbor stated that they'd received a complaint regarding his behavior on December 5th, regarding yelling, screaming, pounding on the walls, and swearing. That language shared between the two households was inappropriate, not acceptable, and a violation of the lease. It then went on to say that the complainant complained that neighbor called him a fucking faggot. It stated this type of language, quote, is not only inappropriate, but also discriminatory. You need to be very careful with the words and terminology used moving forward to avoid your tenancy being terminated. It is important for everyone that lives and works at the property to be free of any harassment or discrimination, end quote. It is important to note that this was really the two households having different stories, and there was no other evidence to support either person's story other than this recording that was not clear. There were no other witnesses, and again, respondent couldn't hear anything on the recording. Thus, there was not enough evidence to terminate either tenant's tenancy, because anybody that's gone to court knows we need to have evidence in order to terminate a tenancy. The letter to the complainant on the same day addressed that he had told a gay joke to a maintenance person and told him that that was not appropriate. It also addressed him pounding on walls and hanging out his window, yelling at the other neighbor. Both letters told them, to the extent to which this occurred, please know that this is not acceptable behavior and would be a violation of your lease. They were also both offered the opportunity to transfer units, which complainant chose not to do, but neighbor did do. It is also important to note that complainant has a long list of complaints, which is part of that 1.5 inch emails, not just about this neighbor, but about the other two households that have lived in that same unit during the time of his tenancy. Noise complaints against his neighbors have been ongoing, many of which are unreasonable. He has filed complaints about neighbors talking after 8 a.m., a dog barking when there is movement outdoors, people having sex, playing a TV in the living room during normal daytime hours, using noise canceling machines, walking their dogs in the backyard, dogs peeing on the snow, etc. It makes it more difficult to find his complaints credible as a result of these lists of complaints that have been unsupported by the evidence or just unrealistic expectations. Furthermore, again, we have to have evidence in order to move forward. With regards to the notice of intent, on June 28, 2022, respondent received a copy of an anonymous letter that complainant references in his complaint. That letter was not sent by the respondent, and respondent had no part in it. When respondent learned of it, they immediately contacted the police, and the police said that they were going to do an investigation. Respondent also did their own investigation, but they had no evidence that anybody on the property had sent that letter. Complainant went around knocking on people's doors and demanding the letters back. This bothered some of the tenants, and they complained about that. A week later, on July 8, 2022, an incident occurred with complainant. Two tenants were getting out of their vehicle when complainant came to them and began talking to them. He complained about other tenants and that one of them had startled him in the laundry. He then proceeded to pull out his taser and wave it around, saying, quote, "I'm not afraid to pull this out and tase any motherfucker who says or looks at me wrong," end quote. He then pressed the button on the taser, making it go off, and made the baby that was in one of their arms scream and cry. The tenant came straight to the office, was still visibly upset about the incident, and reported it. Management found the tenant credible, along with the written statements that two people provided, and also, in addition, the fact that respondent already knew that complainant had a taser from when he told them back in 2018. Those two incidents are the reason for the notice of intent. Complainant found that in a short period of time, there had been two incidences, both with credible evidence that complainant had engaged in behavior that was scaring other tenants or interfering with their rights to peaceful enjoyment. So they issued a notice of intent. Yes.
That's 8 minutes, just so you know.
Okay, great, thank you. I want to just finish by saying that complainant remains a tenant at Windward at the apartment complex. He has not been evicted. He has not had any further notices at this time. And I'll leave my last few minutes. Thank you.
Thanks. We have about 1 minute and 45 seconds when we come back.
Thank you.
Commissioner, questions for Attorney Russell? All right, seeing none. Attorney Neal, you have 3 minutes.
Thank you. Just wanted to follow up that this will go in part towards the retaliation component of my client's claims, is that he does report that he acknowledged that there were sex-based statements that he reported to respondents multiple times. Whether or not they have documented that in their own internal information, that is something that I understand is something that is a disputed fact in this case. Also, and to be clear, even though my client has made complaints over the time of his tenancy that may not be related to things based on sexual orientation or other protected class status discrimination, that doesn't make his complaints about sexual orientation or sex-based discrimination complaints any less credible or noteworthy, or things that shouldn't be followed up on just because he might have complained about noise related to other tenants. And that's something that I believe is something that shouldn't be forgotten. And then to touch on the issues related to the incident with the neighbors who complained about the taser, this is also a disputed fact that happened in the case, in that my client reports that he did not have a taser with him. He did not have one with him, that these tenants are ones who were talking about what happened on June 16th with him and neighbor, that he doesn't carry his taser with him on a routine basis or have it ever leave the apartment. And that these tenants then went and talked to property manager 2, allegedly the same day or nearby when this happened. But then it took property manager 2 affirmatively reaching out to them to follow up to ask about written complaints for 25 days. And if they felt so unsafe, it took property manager 2 25 days with property manager 2 following up and asking for written statements, where during this entire time, the respondents did not reach out to my client or ask about the incidents that happened between these other neighbors and my client. And I think that just a quick note, if I still have time, is that I believe that receiving a notice of intent to terminate is not just not a usual lease violation notice, that is something that would give someone a materially adverse action related to their tenancy. It's a threat, and that threat was based, that notice of intent was based on not just the instance that happened with the other neighbors, but many other instances that are directly linked and tied to my client's sexual orientation and or sex, and that those are connected, and there should be a finding of reasonable grounds related to retaliation in this case. And I'm happy to answer any questions that you might have.
Any commissioner questions for Attorney Neal? Commissioner David.
Attorney Neal, what is the retaliation? The letter of the notice of intent to terminate?
Correct. The notice of intent to terminate was essentially a shot across the bow to my client of stop making these complaints about discrimination or we're going to kick you out of here. He got a notice saying, if you do not change your behavior, we are going to move to evict you from this complex. And that was only sent to him or served on him after he made the report about the letter in June of 2022. And it was only after the other neighbors complained about the alleged taser incident that he has a factual dispute about in terms of the case, and where he was not spoken to as part of that investigation. But then it took property manager 25 days to figure out if the other tenants were going to complain about it and him following up.
You say, so it is after the description of the taser incident, and you say that your client says that they made up
Correct.
an incident in which they go and they tell the managers that he displays the taser and that he fires it to show what it can do, not to anybody, but that he discharges it.
That is correct. My client does not carry a taser with him routinely. He hardly ever leaves his apartment. And these are neighbors that he had other conflicts with in the past and who were not found to be credible in other aspects related to some of their reports to the respondents over time about the case.
Okay. It strikes me in my experience in cross-examining people about factual incidents that when you have that stark a disagreement, then you do need to make a judgment about who's credible, right?
Correct.
You would agree that if they're found to be credible, immediately describing that incident about the taser, that would certainly justify the shot across the bow, would it not?
Potentially, but these individuals were not interviewed as part of the investigation. This was just based on respondents' report about what they learned from these neighbors who made that complaint. And so there wasn't actually a credibility determination made about the credibility of these individuals who made the complaint about that particular instance.
Credible enough for the respondents to recite them. But okay, thank you.
Any other commissioner questions for Attorney Neal? Seeing none, Attorney Russell, you have 1 minute and 45 seconds left.
Thank you. I just want to respond that, again, my clients state that these particular tenants came in, they were still visibly upset. And I'm not sure where the statement that they waited 25 days to put the written report back to my client is in. If I remember correctly, the date was July 8th. And our record shows under Defendant's Exhibit B that that would have been a Friday, and on the following Monday, an email was sent by one of the tenants. And later that day, the second email was sent by the other tenant, reiterating what they had reported in person right after the incident. And again, my clients found that credible based on the way that they appeared, as well as the fact that they had this knowledge from the complainant himself that he did in fact own a taser, which is a piece of information that these tenants could not have made up unless it had been communicated to them.
Any commissioner questions for Attorney Russell? All right, seeing none, thank you both. We will next hear from Investigator Hurd.
Hello again, commissioners. I'm Investigator Hurd, the investigator for this case. So I think it's important to reiterate that complainant's claims of harassment against neighbor, which the complainant brings up in its submission of disagreement, were beyond the 300-day jurisdiction of the commission. I understand the complainant's making the argument that those events go towards establishing a pervasive hostile environment against complainant based on a sexual orientation, but I don't think the record backs that up. For one, the events are not continuous. So the neighbor, for example, isn't the one who wrote the letter. It is in the record that police have discovered who wrote that defamatory letter, and that is its own thing. It's ongoing investigation, and that neighbor was not part of that. The second is that the video that complainant himself submitted shows, it was pretty clear to me and pretty convincing that neighbor, at least in that circumstance, was not directing the statements he was making at complainant. He was yelling them through the wall. However, there was loud music. There was a lot going on. It seemed to me like this neighbor has some sort of rage or aggression problems, and he was not yelling these things at anyone in particular, but just yelling them. There were altercations between the two of them that came up later and that are in the record. Again, these are all before the 300-day jurisdiction, but it's based on the extensive amount of emails that I read that respondents submitted about these complaints. These complaints were made based on the noise coming from this neighbor's apartment and not based on direct discriminatory behavior against complainant. And then also, there is also evidence in the record that neighbor treated everyone at the complex this way, sort of rude and aggressively. As complainant references in its submission, that neighbor was evicted eventually for behaving in a similar way to another tenant. Regarding the statement that property manager 1 knew about language, that this inflammatory language that was used by neighbor, I think what property manager knew was that complainant was alleging that he was making those statements. He did not have firsthand knowledge of those statements, except for the video that he saw. And as respondent pointed out, it was not clear what exactly was being said, just that someone was yelling. There may have been not slurs, but some aggressive, improper language in there. And there was a back and forth in this investigation, and respondent did investigate it, and it didn't come to the conclusion I think the complainant would have liked it to. Let me see. As for respondents being more responsive to a female neighbor's reports of neighbor's behavior, I did not investigate that because I didn't think that was relevant to this case. So I don't know what neighbor did there that was different or not to justify evicting him in that case. Nor do I find it pertinent to speculate about the property manager's possible unconscious motives in making decisions in that unrelated case. Otherwise, I feel like the report pretty much stands for itself, and I'm happy to take any questions.
Questions for, yeah.
Yeah, good morning, Mr. Hurd. Just a brief question, because I think that Attorney Neal would say that how the female body tenant was treated is entirely relevant to what we needed to do here. And so I would just like you to explain a little bit more why you felt that that was not relevant and therefore not really worthy of looking into.
I think that, so as I said, there was the altercation, the investigation. Respondents ultimately gave both parties the option of moving to a different apartment away from each other. Whatever happened after that was not related to complainant or discrimination against complainant. Therefore, it didn't seem relevant to an investigation on whether respondent was discriminating against complainant based on his sexual orientation.
But I think that what Attorney Neal, I'm speaking for Attorney Neal here, but I think what she would argue then is that it is relevant because, the complainant had experienced a pattern of discrimination over a period of years. I understand a lot of that is before the 300-day deadline, which you made very clear. The fact is that he experienced discrimination for a period of years. Her position is that, these complaints went largely ignored. He had a recording. The recording wasn't good enough. I've heard your explanation. But then, this woman makes a complaint, and within 6 months, he's out of there. So I think that would be her position.
Yeah, I understand that. I guess I disagree that it was relevant here because, for one, the complainant's allegations that sexual orientation discrimination occurred at all were suspect to me. So yes, there is that language in there that complainant alleged was used. But it appeared to me that that was not because complainant was gay. It was because respondent had a rage problem and complainant was making noise complaints against him. I think that that's what happened. And then there's also evidence in the record, it's not in the report, that complainant has had several interactions with many of his neighbors over the years, not about his sexual orientation, just about, and I think respondent was kind of hinting at this with including all the additional evidence, that he's made a lot of complaints against a lot of people for a lot of reasons. I don't know that, it didn't seem to me like there was any discrimination against him for being gay. It seemed to me that he is gay and people were, he was maybe engaging in behavior or personality traits that his neighbors did not like or appreciate. And so they were reacting to that. And there's a correlation, but not a causation there, I think. Sorry, so I said all that to get back to your question, I guess, about why I wouldn't investigate, why they kicked out the neighbor in this other case. I guess, yeah, I don't really have anything else to add to that, except it didn't seem relevant to this particular instance.
Okay, thank you. Attorney Neal, my apologies for using improper pronouns. I need to look at the screen a little more closely. My apologies there.
Any other commissioner questions for the investigator? Right, seeing none, thank you, Colin. We've heard from the parties and the investigator. At this time, we're looking for a motion. There are two proposed findings. No reasonable grounds to believe that respondents discriminated against complainant based on disability, sex, and/or sexual orientation or gender identity, and no reasonable grounds to believe that respondents retaliated against complainant for engaging in MHRA protected conduct.
I'll move to take them together and to support the investigators' conclusions and move that we find that there are no reasonable grounds to believe that respondents discriminated on the basis of sexual orientation or gender, and no reasonable grounds to believe that there was retaliation in violation of the MHRA.
Second.
All right, and just so I'm clear, Ed, it's the first finding is that there are no reasonable grounds to believe that respondents discriminated against complainant on the basis of disability, sex.
Disability, sex, yes, all of them.
Okay. So moved and seconded, any discussion?
It just seems to me that complainant is demanding that respondents change attitudes of other people as opposed to specific behaviors that respondent can be responsible for. The clear indication of an action taken is the notice, and I think that's justified by the taser. I conclude I will take the investigator's conclusion that that incident happened based on the reports that respondents submitted.
Any other discussion? Seeing none, the motion is to find no reasonable grounds on both findings. If you're in agreement, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Right. The findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and council confirming the results of the hearing.
All right, I'm not sure I see someone here, but we'll call the case anyway. Our last case on our agenda is H23-0200. It's Paul Lowe's versus Walter Rideout. This is a no reasonable grounds case, so we should hear from the complainant or his representative.
Just go check the waiting room one more time. I don't believe we're expecting complainant to be here though.
now, everyone on this meeting is employed by us, so.
Excellent, have it lunch.
Go for it.
Several people in the waiting room, but none of them are here for this.
Going once,
I just walked in on somebody else's meeting.
going twice. All right,
All right.
still entertainable.
Good job,
Great.
Angela.
Thanks, Angela. All right, so yes, when the parties don't participate in the meeting, we just move straight to a motion. There are, one moment, two proposed findings. No reasonable grounds to believe that respondent discriminated against complainant on the basis of disability, and no reasonable grounds to believe that respondent retaliated against complainant. Do I have a motion?
I would take them together. There are no reasonable grounds to believe that Walter Rideout discriminated against Paul Laus on the basis of disability, and no reasonable grounds to believe that Walter Rideout retaliated against Paul Laus for engaging in MHRA protected conduct, and the complaint should be dismissed.
Second.
Okay, moved and seconded. Any discussion? Seeing none. The motion is to find no reasonable grounds on both counts. If you're in agreement, you will vote yes. Commissioner Ashby?
Yes.
Commissioner Davis?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
So the findings are no reasonable grounds. We appreciate the commissioner's participation in this case, and we will send a letter to the parties confirming the results of the hearing.
Pursuant to 1 MRS section 405-6E, I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Second.
Moved and seconded. Any discussion? Seeing none. All in favor, Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
All right.
Back to you for you to get back to me next month.
Great.
Are we,
We're not quite yet.
was listening.
5, 4.
Better get his butt to the office.
All
Okay,
right, can we combine the motion? Can we combine the
You sure
in
can.
one motion? All right, I move that we approve the conciliation agreement in H 230095 A and B. That's Curtis versus Trustee Wrench, and that we approve the conciliation agreement in. Sorry, I had it. I just had it. in front of me.
HEPA 21-0319.
Thank you.
All right, do I have a second?
Second.
Moved and seconded, any discussion? All right, seeing none, if you vote yes, you are in agreement. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Great.
Move to adjourn. Second.
I don't think we actually need a motion for that, do we?
But they like to do it.
They like it, okay, great, moved and seconded, all in favor, fantastic.